Members of the Board of Equalization want to hear from you. If you have ideas, concerns, or suggestions on how the board could improve services in the taxpayer experience, make sure to attend the annual Taxpayers Bill of Rights hearings in Culver City on April 26th or Sacramento on May 24th. If you'd like more information, visit boe.ca.gov.
Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
Oh.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you, good for California.
The Taxpayers' Rights Advocate of the State Board of Equalization wants you to know you have rights. As a California taxpayer, your rights are protected during the assessment and collection of taxes, including the right to courteous and prompt service and the right to be treated fairly during all dealings with Board of Equalization employees and officers of the board. Publication 70, Understanding Your Rights as a California Taxpayer, and Publication 145, California Taxpayer Advocates, can be useful in learning about your rights. If you feel the BOE has not resolved your concerns adequately, please contact the Taxpayers' Rights Advocates Office at 1-888-324-2798 or email us. The Taxpayers' Rights Advocate of the State Board of Equalization. We're here for you.
You asked, and we listened. Together, we've designed a California State Board of Equalization website with you in mind. The convenient login button allows you to access many of our online services from anywhere at any time. Drop-down menus make navigation easy. You can do everything from filing a return and making a payment to finding permits and licenses. Our interactive banners highlight the latest news, programs, and services. Popular topics help you find information quickly. The How Do I and Business Center sections offer you even more helpful resources, including individual tax guides for various industries. We also want to hear from you. Tell us, how was your experience? Your feedback is important because it helps us provide you with an improved and more interactive website. So check it out at boe.ca.gov. It's designed with you in mind.
It's easy to buy things online these days, but did you know you may need to pay tax on those items?
Really?
It's called use tax. And just like sales tax, the use tax you pay to California will help fund important services like public safety, healthcare, and schools. But how do you know if you owe use tax? When you buy things online, look to see if you were charged tax when you checked out. If you weren't, you may owe use tax. It's easy to figure out how little you may owe. For most purchases, you don't even have to save your receipts. Just use this convenient use tax table, available in your income tax instructions. Find your adjusted gross income to see how much you may owe, and enter that amount when preparing your state income taxes. It's that simple. No looking through files and no hassles. You've paid your use tax for the whole year.
That was easy.
Paying your use tax. Good for you. Good for California.
We're committed to supporting our communities, teaming up with businesses large and small, improving our roads and schools, investing in law enforcement and our environment. Together, we're funding a better quality of life. We're the California State Board of Equalization. The BOE was created in 1879 to equalize property tax assessment practices throughout California. Our responsibility has grown quite a bit since then. Today, the BOE administers more than 30 taxes and fees that provide 1/3 of all the revenue generated in our great state. And we're efficient. More than 99% of the money you contribute supports services and programs that benefit all of us in California. When you drive down our many highways, see a police officer helping someone in need, or enjoy a walk along a pristine beach, think about what makes it possible. Whether you're a business owner, making a purchase, or just filling up your gas tank, your contributions are important to our state's economic health. And the greatest part, we're doing it together. We're ready to work with you. Take advantage of our free seminars, helpful classes, instructional videos, and mobile applications. Also, use our online services. It's easy to do business with us from anywhere, at any time. Our partnership equals success. Learn more at boe.ca.gov. Together, we're supporting our communities and funding a better quality of life.
Welcome to the State Board of Equalization. Ms. Richmond, will you please call the roll to determine that a quorum is present?
Yes, ma'am. Chairwoman Ma,
Here.
Ms. Harkey,
Here?
Mr. Horton, Mr. Runner. Here. Ms. Stowers.
Here.
Okay, thank you. With at least 3 members of their designated representatives being present, there is a quorum, and the meeting of the Board of Equalization is hereby called to order. We are going to do the Pledge of Allegiance. Mr. Gal, will you please lead us in the pledge?
Everybody rise to join. I pledge allegiance.
Thank you. You may be seated. Mr. Ferris, is there anything that we can take up now until Mr. Horton arrives?
You can take up any matter that's on the agenda for today.
So G and H items?
Yes.
Okay, Ms. Richmond, perhaps we could take the G item first?
Okay. So our first item on this morning's agenda will be item G, Tax Program Non-Appearance Matters Consent. These items may be taken in one vote. Sub-items 7A and 7B have been previously pulled.
Okay, members, is there any non-participation on any of these items? Or would any items, members like any items to be pulled for further review? Okay, is there a motion?
Move staff recommendation.
Second.
Okay, Mr. Runner moves staff recommendation. Ms. Stowers seconds. There's no objections. We will move to adopt staff recommendation on items G 1.1 to G 1.6 and G 1.8 to G 1.19. Without objection, motion carries.
Our next item is G2, Franchise and Income Tax Matters. These items may be taken in one vote.
Okay, members, are there any non-participation on any of these items, or would any member like to pull any item for further review? No. Hearing none, is there a motion?
Move staff recommendation.
Is there a second?
Second.
Okay, Member Stowers moves to adopt staff recommendation on items G2.1 to G2.13, seconded by Member Runner. Without objection, motion carries. Ms. Richmond, next item.
Our next item is G8, Property Tax Matters. This is a constitutional function, therefore the Deputy Controller may not participate in this matter under Government Code Section 7.9, and there's only one item.
Okay, members, G8, Property Tax Matters. Is Mr. Kinney here to present? Is it G8?
Yes.
Do we need Mr. Kinney to present, or no?
Move staff recommendation.
Okay. Ms. Harkey moves staff recommendation, seconded by
Second.
Mr. Runner. Hearing no objections, noting non-participation by Ms. Stowers, we will move to adopt staff recommendation on item G8.1. Without objection, motion carries. Ms. Richmond, next item.
Our next item is item H, Tax Program Non-Appearance Matters Adjudicatory. Item H2, Franchise and Income Tax Matters. These items may be voted on separately or in one vote.
I'd like to take them separately, I believe.
Okay. Member Harkey would like to take these items, each item separately?
Yes, let's just do it. I've got different instruction here.
Okay. Okay. Ms. Richmond, please call each item separately, and we will take each one up separately and vote separately on each one.
Okay, item H21 is a hearing notice and appearance waived. Michael McGuire.
Move to deny the appeal.
Second.
Okay, members, any discussion? Hearing none. Member Harkey moves to adopt staff recommendation, seconded by Member Stowers. Without objection, motion carries. Next item.
Our next item is H22, decision for Jose Borges and Laura Borges.
I need a little discussion on that. It's okay to discuss this matter, is it not, Chief Counsel? Okay. I think in this case, it would be prudent to reduce the demand penalty to $495, which is, the demand penalty is permissive, it's not required, and 25% of the total amount of tax would be $495, not the amount that is being assessed. Change the refund difference of $1140. So the total amount, demand penalty minus $11,535 minus $495, or $11,040. So I make a motion to have the total grant the appeal for the refund of $495 and adopt staff recommendation for the remainder. That corrects it? I think that's what we're doing.
Okay, do we understand
Any
that?
discussion?
So you're saying allow a refund of $495, you're reducing the demand penalty?
Right.
And how did you get there?
Well, the demand penalty is either 25% of the total amount of tax, or it's permissive and nothing. And I think 25% is $495. 25% of $1,918 or $981. Total tax is $1,981, and 25% of that would be $495.
Oh, so your the demand penalty is 25% of the tax prior to withholding.
Right.
So you're saying the tax is $1,000, so you're giving them credit for withholding.
Right. Taxpayer underpaid their tax liability by $1,981 via estimated tax payments prior to the April 15, 2008 deadline. So they did pay, they were just short $1,981. And the demand penalty is a permissive statute, it's not mandatory, and it's written in the alternative such that either option could apply. Either you take 25% of the amount of tax due, or not at all. So I think the 25% is the midpoint.
I understand what you're saying. I want to discuss it too.
Okay. Thank you.
To appeals. From my understanding, the Franchise Tax Board has conceded that, check my facts right, that the appellant husband had reasonable cause for not filing timely and not responding to the demand notice, but they're arguing that the appellant wife did not have reasonable cause.
That's correct.
And the reason for the appellant wife not having reasonable cause for the late filing penalty, I follow, you know, she had a duty to actually file a return on a timely matter as well. Where I'm struggling is, where is her duty to open the appellant husband's mail and respond to the demand notice on his behalf? I know that FTB cites cases about joint and several liability, but to me, I'm still not there on how she has the responsibility to open his mail. Can you discuss that, please?
We extended the same rationale for the responsibility for filing the return that the wife has on the joint return, that same responsibility to the responsibility for opening the mail, such that she would also be responsible for responding to the demand in the absence of the husband doing it, despite his illness.
Have we done that before?
This would be the first time that we would have addressed this issue.
Let me just,
I And during this time period when the demand was issued, there's reasonable cause because the appellant husband was ill.
Correct.
And the assumption is, or my assumption is that the appellant wife was caring for her elderly sick husband. I find that she also has reasonable cause as well. My recommendation would be to cancel the demand penalty in full.
I would agree. I didn't think I'd get there.
Is that a substitute motion?
Yeah, you went off for substitute.
That's a
I don't
substitute.
think I had a second, so I think
That's a
the
substitute motion to cancel the demand penalty in full, but the late filing penalty would stand, the collection cost recovery fee would stand, and the lien fee would stand.
Okay.
A second.
So all other
All-
penalties will stand except the demand penalty. Any discussion, Mr. Warner? Mr. Ward? No? Okay, there has been a motion and a second to cancel the demand penalty in full. However, all other fees and penalties will stand. Motion is by Ms. Dowers, seconded, the motion is by Ms. Dowers, seconded by Ms. Harkey. And without objection, motion carries. Okay, Ms. Richmond, next item.
Our next item is H23, petition for rehearing for Michael J. Bills and Mary E. Bills.
I move to deny the petition.
Second.
Any discussion, members? Okay, hearing none. The motion to deny the petition for rehearing, adopt staff recommendation, was made by Ms. Harkey, seconded by Ms. Stowers. Without objection, motion carries. Next item, Ms. Richmond.
Our next item is H24, petition for rehearing for Robert E. Valdez and Judy M. Valdez.
I move to deny the petition for rehearing.
Any discussion, members?
Second.
Okay, second.
Second.
Seconded by Mr. Runner.
Objection.
Objection noted. Let's take a vote.
Ms. Ma,
No.
Ms. Harkey,
No.
Mr. Horton,
Or, excuse me, yes. I made the motion. Sorry.
It'll be awful minute there. No.
Mr. Runner,
Aye.
Ms. Stowers.
No.
Okay, is there a substitute motion? New motion?
Move to grant the
Stowers?
petition for rehearing.
Second.
Can I ask Ms. Stowers, is it a petition for rehearing but not adopting staff recommendation or
Oh,
adopting?
it is, I'm sorry. Adopt staff recommendation to grant the petition for rehearing.
I'd like to make a substitute motion to adopt staff recommendation for rehearing, or to adopt, or for rehearing, but not adopt staff recommendation.
I would second that motion. Do we need a little explanation?
Yes, please.
Mr. Ferris? So Ms. Harkey's motion is to approve the petition for rehearing, but not adopt staff recommendation.
To not adopt the proposed decision
Oh, not
is,
adopt proposed decision.
Right.
right.
So amended.
So they would still get a rehearing.
Yes.
There would still be a rehearing.
Yes.
They have an opportunity, yeah.
But the staff's proposed decision would not be published because the board would not have adopted it.
Okay. I can live with that.
Yep.
Okay, members. Okay, motion by Ms. Harkey, seconded by Member Ma. Seeing no objection, motion carries. Okay, Madam Clerk, Ms. Richmond.
Our next matter is H25, a Section 40 matter for Craigslist, Inc.
Any discussion, members?
Adoption of staff recommendation.
Second.
Any discussion, members? Ms. Harkey?
I'm going to abstain. I know it was a 5-0, but I think I had some concerns with the decision and had made an alternate or a motion first on this and then decided to go along with the majority in the final vote, but I'm just abstaining on the opinion. Thank you.
Any discussion? Okay, so the motion to, I believe the motion, maybe you can clarify the motion. Is it to
To adopt the summary decision.
summary decisions? Okay, seconded by Ms. Stowers, with Ms. Harkey abstaining. Without objection, motion carries.
Our next item is H26, a Section 40 matter for Jesus Zhao.
Move to adopt summary decision as drafted.
Second.
Any discussion? No discussion, okay. Member Harkey makes the motion with Member Horton seconding the decision to make these cases summary decisions, therefore non-precedential. Motion carries.
Our next matter is item I, tax program non-appearance matters. These are constitutional functions, therefore the Deputy Controller may not participate in these matters under Government Code Section 7.9. These items may be taken in one vote.
Okay, members, any discussion?
Move to adopt staff recommendation on all items. Second.
Member Horton recommends adoption of staff recommendation on all items. Member Runner seconds, noting non-participation by Member Stowers. Without objection, motion carries to adopt staff recommendation on items I 1.1 to I 1.11. Ms. Richmond, next item.
Our next item is I2, offering compromise recommendations. These items may be taken in one vote.
Any discussion, members?
Move to authorize staff to accept all offers and compromises.
Okay, is there a second?
Second.
Okay, Member Horton moves to adopt staff recommendation on items 1.2.1 to 1.2.14, seconded by Member Stowers. Without objection, motion carries. Next item, Ms. Richmond.
That concludes our non-appearance matters. Next, would you like to take up our oral hearings?
Yes, let's start with the oral hearings.
Our first oral hearing for this morning is item B, corporate franchise and personal income tax appeals hearing. Item B1, Kamil Issa, please come forward. Board Proceedings has received contribution disclosure forms for today's hearings from the parties, participants, and agents. All forms are properly completed and signed. No disqualifying contributions were disclosed. All parties, participants, and agents are on the alpha listings provided to your office. Each person sitting at the table will be asked to introduce themselves and, if necessary, their affiliation with the taxpayer for the record. 10 minutes is allocated to the taxpayer for opening presentation, followed by 10 minutes for the franchise tax boards or department's presentation, and 5 minutes is allocated to the taxpayer for rebuttal. Chairwoman Ma.
Okay, thank you, Madam Clerk. Let's commence with introductions.
Good morning. Oh, go ahead.
Introduce the appeal real quick. Good morning, Chairwoman Ma, members of the board. John Johnson with appeals. There are 3 issues in the appeal before us. The first is whether appellant has shown error in the franchise tax board in not allowing damages awarded in a settlement agreement to be excluded from his taxable income. The second issue is whether appellant has shown that he's entitled to deduct attorney's fees and costs. And the third issue is whether appellant has shown error in the imposition of the late filing penalty.
Thank you, Mr. Johnson. Appellant?
Oh, good. Good morning. Thank you very much for, Ms. Chairwoman and the members of the board, thank you very much for allowing us to be here. My name is Mark Muntean. I'm the attorney for Kamil Issa. Mr. Issa is sitting here to my left. Again, we appreciate your time. Because of limited time, I will run through the facts briefly and then what we believe the rules are in this matter.
Mr. Muntean, before you begin, you have 10 minutes to make your initial presentation, and then you will have an additional 5 minutes on rebuttal. So thank you very much, and please begin.
Right. So briefly going through this, Mr. Issa immigrated to the United States in 1990 as an immigrant from Lebanon. He was escaping persecution as a Christian in Lebanon. He had odd jobs and eventually worked for FedEx as a FedEx ground driver. During that period, Mr. Issa was sexually abused at his work. This is kind of embarrassing for him, so, I'll kind of talk about this as ginger as possible. But over a dozen times he was sexually abused at work. He was grabbed on his bare reproductive organs, if you will, and oral sex was demanded at the same time by his supervisors. He was forced to the ground at his work and told to provide oral sex to his supervisors, which of course he didn't comply. He was shoved around the office. He was punched around the office, and not just shoved gingerly, just shoved 6 feet into filing cabinets. So it was a physically abusive workplace. Without going into too much detail on that, he brought his case through the Fair Employment and Housing Administration to avoid workers' comp. The Franchise Tax Board will probably tell you that the complaint talked a lot about discrimination, talked a lot about name calling, and that was to strategically avoid workers' comp, because workers' comp, the attorney's fees are capped, and in workers' comp, the recovery is capped. By passing through the fair employment, he was offered an opportunity for unlimited attorney's fees and unlimited recovery. That's a very, very, very common strategy in cases like these brought by plaintiffs' attorneys. So he ended up recovering $2,653,770,000 from FedEx through 5 years of hard-fought litigation. The attorney's fees were roughly $2,721,230 for the attorneys. So it was a total recovery of $5,375,000. The attorney's fees were paid directly to Chris Dolan, his trial attorney. There were 2 plaintiffs. The second plaintiff is not here because the second plaintiff settled with the Franchise Tax Board, basically due to the embarrassment. That's just part of this case. This is a very embarrassing matter for him to be here on. So I briefly mentioned what happened, and procedurally, the jury originally awarded $25 million to the plaintiff. And I've said this in my pleadings, I've said this time and time again, no jury awards $25 million for name calling. You'll hear a lot about name calling. There was a lot of testimony at court about name calling, but there was also a lot of testimony about the seriousness of the sexual abuse that took place. And that was a shocking element for the jury. The appellate, the court offered a remittitor. The taxpayer rejected the remittitor. The case was appealed to the Court of Appeals. While pending, it was mediated, and at the mediation, a settlement agreement was entered into between my client and FedEx. I think everybody has a copy of that settlement agreement. On page 2, section 2, the settlement agreement allocated the recovery to emotional distress and emotional distress connected to physical injury, personal physical injury. Why do I mention that? Because the Internal Revenue Code says under section 104A2 that personal injury and then emotional distress connected with personal injury is not taxable. It's excluded under 104A2. Do we follow settlement agreements? In a field service advisory, the Internal Revenue Service said, yes, we follow settlement agreements. If it's a bona fide adversarial fight, which this was 5 years of hard-fought litigation, they say if the terms are consistent with what was argued to the jury, which it was, transcripts of what the trial attorney actually argued to the jury state that, sure, there was a lot of name-calling, but this was about sexual abuse. And then finally, was the settlement entirely tax-motivated? This settlement wasn't tax-motivated at all. This was a fight. And it was a fight for many years, right down to the end. And then sexual abuse, what does California do? California conforms to the federal. Now, in 2008, the IRS issued a Chief Counsel memorandum. It's 2008-09001, where the IRS said sexual abuse is personal physical injury under Section 104A2 of the Code. So the IRS has laid down the precedent in 2008. California conforms to the federal, and so the Chief Counsel memorandum would be the law in California as well. I apologize for running through it really quick, but I was worried about the 10 minutes. I want to give time if you have any questions for us.
Thank you, Mr. Montine. Franchise Tax Board, you will have 10 minutes to make your presentation, and then we will return back to the appellant for rebuttal. Please introduce yourselves for the record.
Chairwoman Ma, members of the board, I'm Judy Hirano. Beside me is Chiro Imardino. We represent the Franchise Tax Board. Generally, all income is taxable unless it falls within certain exceptions. Internal Revenue Code Section 104A2 provides a limited exception for damages received from a lawsuit or settlement agreement because of physical injuries or physical sickness. In 1996, Congress amended Section 104A2 to limit the exclusion of income to lawsuit proceeds and settlement payments received because of physical injuries or physical sickness. The issue here is whether appellant received the settlement payments from a lawsuit against his former employer because of physical injuries or physical sickness. Appellant filed a lawsuit against his former employer and certain individuals for claims under the California Fair Employment and Housing Act. He alleged discrimination and harassment based on race or national origin, discrimination and harassment based on sexual orientation, retaliation, and failure to take reasonable steps to prevent the discrimination and harassment. The lawsuit complaint alleged no claim for physical injuries or physical sickness and identified no physical injuries or physical sickness for which appellant sought damages. Appellant requested damages for loss of wages and emotional distress, punitive damages, attorney fees, and costs. After a jury trial, the trial court determined there was sufficient evidence for only 3 of the claims alleged in the lawsuit complaint to be submitted to the jury for a decision: harassment based on race or national origin, retaliation, and failure to take reasonable steps to prevent the harassment. The jury returned special verdicts finding the defendants liable for only 2 claims: harassment based on race or national origin, and failure to take steps to prevent the harassment. These claims are not for physical injuries or physical sickness. The jury awarded appellant $5 million compensatory damages for emotional distress. Damages for emotional distress are taxable. After a separate punitive damages phase of the trial, the jury also awarded appellant a significant amount of punitive damages. Punitive damages are also taxable. The compensatory damages for emotional distress and punitive damages were awarded for harassment based on race or national origin and failure to take steps to prevent the harassment, not for physical injuries or physical sickness. The defendants then filed a motion for a new trial. In ruling on the motion, the trial judge reduced the damages to $750,000 compensatory damages and $5.2 million punitive damages. The reduced amounts of damages the judge awarded were for harassment based on race or national origin and failure to take steps to prevent the harassment. After the trial, the parties filed appeals and cross-appeals. They then settled the lawsuit. The settlement agreement stated the parties wished to settle the lawsuit and the complaints appellant had filed with the California Department of Fair Employment and Housing, as well as any other potential claims he may have against the defendants. Pursuant to the settlement agreement in 2006, appellant received a settlement payment of $1 million. In 2007, he received a second settlement payment of $1.6 million. In addition, the law firm representing appellant and a co-plaintiff was paid $5.4 million in attorney fees and costs in 2006. The settlement payments are taxable since the appellant did not receive the payments because of physical injuries or physical sickness, as required by Section 104A2. Rather, the settlement payments were made in lieu of damages for emotional distress and punitive damages for harassment and failure to take steps to prevent the harassment. Damages for emotional distress and punitive damages are taxable. The claims the parties settled were in the nature of harassment and failure to take steps to prevent the harassment, not physical injury or physical sickness. The lawsuit complaint contained no claim for physical injuries or physical sickness and identified no work-related physical injuries or physical sickness for which appellant sought damages. Thus, no claim for physical injury or physical sickness was submitted to the jury for a verdict. Rather, the only claims submitted to the jury were for harassment based on race or national origin, retaliation, and failure to take steps to prevent the harassment. The only claims for which the jury found defendants liable were for harassment and failure to take steps to prevent the harassment. Thus, the jury awarded damages for harassment based on race or national origin and failure to take steps to prevent the harassment, not for physical injury or physical sickness. The trial judge, in ruling on the motion for a new trial, awarded in reduced amounts compensatory damages for emotional distress and punitive damages, both of which are taxable. He did not award any damages for physical injuries or physical sickness. In reducing the amount of compensatory damages, the judge stated the harassment was essentially offensive ethnic name-calling, although he acknowledged this occurred regularly, almost daily. Moreover, in reducing the compensatory damage award, the judge stated a key factor was the lack of any medical or psychological treatment, although he noted in appellant's culture, men did not readily seek treatment for emotional distress. Thus, the claims the parties settled were in the nature of harassment and failure to take steps to prevent the harassment under the California Fair Employment and Housing Act, not physical injury or physical sickness. The lawsuit complaint contained no claim for physical injuries or physical sickness and no allegations of specific work-related physical injuries or physical sickness for which appellant sought damages. The jury awarded and the judge upheld in reduced amounts compensatory damages for emotional distress and punitive damages for harassment based on race or national origin and failure to take steps to prevent the harassment. Damages for emotional distress and punitive damages are taxable. Appellant has failed to establish the settlement amounts were paid because of physical injury or physical sickness. Thus, the settlement payments are includable in income. Respondent requests that your board sustain its action in this matter. Thank you.
Thank you, Mr. Rono. We will now return to the appellant for rebuttal. You have 5 minutes for rebuttal.
Yeah, thank you. The Franchise Tax Board wants to pretend that there was no sexual abuse in this case, even though I gave them boxes of testimony that prove that there was sexual abuse in this case. They want to pretend that Mr. Issa was never grabbed at work physically. They want to pretend none of this ever happened. They want to pretend that the settlement agreement never happened. The settlement agreement specifically says, and I'll read it for the record, allocation of settlement contribution. Plaintiff, FedEx, intends to treat the settlement payments allocated to the taxpayer pursuant to paragraph 1 as damages for plaintiff's allegations of emotional distress, including emotional stress attendant to alleged physical injury. Why in the world would they put that language in if physical injury never took place? Why would a company the size of FedEx ever do that? It makes no sense. Obviously, there was a lot discussed at the trial. The Franchise Tax Board attempts to leverage off of the trial attorney's strategy of going away from workers' comp to maximize the recovery. I think as a people, we've moved past this ignoring sexual abuse in the workplace. I think we have to recognize that it took place. And I don't think we should call it name-calling anymore. I think we should call it for what it is. If this happened to my wife, if this happened to a family member, I mean, think about it. If it happened to your family member, would you say, oh, yeah, it's a bunch of name-calling? I think as a people group, we need to move past that and recognize the facts and not sweep this kind of thing under the table. I would be appalled if it happened to a member of my family. I would say that FedEx would never have agreed to this in the settlement agreement if it wasn't the truth. And I don't think we can ignore it. And I appreciate your time.
Thank you, Mr. Montine. Okay, members, discussion? Ms. Harkey.
I will start out. This is for the FTB. I understand, and we have read through the transcripts, actually, and I understand that the court, that the ruling on the court was harassment and discrimination. But how is it that you can ignore the settlement agreement?
Yes, let me just read you the settlement agreement. Mr. Montine, I think, misstated that the plaintiffs were FedEx, but that's not correct. The plaintiffs were appellant and another co-worker. And the settlement, the allocation statement in the settlement agreement states, plaintiffs, that is appellant and his co-worker, intend to treat the settlement payments allocated to Issa pursuant to the paragraph 1 as damages for plaintiff's allegations of emotional distress, including emotional distress attendant to alleged physical injury. It goes on. The defendant agrees and consents to plaintiff's allocation of the settlement consideration for such alleged emotional distress damages. So it was the plaintiffs and their attorney who made this allocation. So that they could argue, perhaps in a proceeding like this, that the award was based on physical injuries, despite the claims that were submitted to the jury and on which the jury did find the defendants liable. But a payment allocation statement and a settlement agreement is not controlling if it was not drafted in an adversarial context, at arm's length, and in good faith. And here, there's no indication. It was the plaintiffs who made this allocation statement. It was their intention to allocate the damages to, or the payments to, settlement payments to emotional distress. And the defendant merely acquiesced in that because the defendant had no real interest in ensuring that the allocation was accurate. The defendant merely wanted to limit its liability by, settling this case. And so in this kind of context, where one party is the one that drafted the allocation statement, and the other party merely acquiesces because it has no real interest in opposing the statement, then your board need not find this to be controlling.
Okay, so you're wanting to accept part of the settlement agreement, but not all of the settlement agreement. Did both parties sign the settlement agreement?
The parties did sign the settlement agreement.
Okay, so let me ask one more question.
Yes.
Having read through the testimony, the transcripts, which are quite graphic, are you saying that groping someone either outside or inside his clothing by several people on several occasions is not personal or physical injury?
The complaint made no allegations. This might be assault and battery. Assault is the threat to imminently have physical, harmful, or offensive contact with someone, and battery is the contact itself. That may be assault and battery, but the lawsuit complaint contained no claims for assault and battery.
Yeah, the original complaint was for harassment and discrimination. Those were the two that were charged.
That's correct.
And I believe that there was clarification in the settlement, because $6 million is a far cry from what the settlement was. $6 million, $25 million awarded by the jury was certainly for, they believe, some maybe irreparable harm. And when the judge reduced it to $6 million, and then the settlement reduced it even further, I believe that that one of the conditions for the settlement was that the allocation justify the plaintiff's complaint, that it was including emotional distress attendant to physical injury. And so I would, having read through this and looked at, I'm sorry that this had to come forward, but I think it's pretty obvious that regardless of what was settled, that the jury awarded a huge dollar amount. The judge reduced that, and it was further reduced by the settlement. And that in reading the transcripts, it appears there was a considerable amount of physical contact with the person in personal areas. And so I would think the FTB would want to reconsider at least a portion of this.
Yes, the statement was emotional distress attendant to physical injury or physical sickness, but there must in the first instance be some kind of physical injury. And there's no evidence of that.
I'm sorry, I don't want to interrupt you,
Yes.
but I believe the transcripts kind of lined out what the physical injury was, and rather than getting really graphic in this board hearing, I think the transcripts spell out that there was considerable groping outside the clothing and perhaps even inside the clothing, and that might be considered to some to be a physical sort of injury. So I appreciate your argument, but that's kind of where I am right now.
Thank you.
Mr. Runner.
Yeah, just to clarify, FTB is telling us that they don't believe that sexual abuse would be equates to physical injury?
I know Mr. Montine has mentioned an IRS Chief Counsel memorandum for the proposition that I think sexual contact is physical injury, but that memo doesn't say anything about sexual contact. Okay.
So you're saying no. You're saying you do not. The FTB does not believe that sexual abuse equates to physical injury.
Well, it could equate to a physical injury, but there is no sexual, there's no allegation that there was any injury based on any of a physical injury based on the.
So you would believe that sexual abuse would only be physical injury if there was what? Harm, bleeding, bruises?
Well, more than groping. I think groping might be some kind of sexual harassment, perhaps.
Okay,
but
thank
not
you.
necessarily.
Let me go back to the taxpayer rep. Walk through again for us why it is, because it seems to me that taxpayers get in this catch-22 position in regards to workers' comp, and why it is that then again they don't file a workers' comp on the fiscal issues, and why don't you go through why would this not be the best interest of an individual to just file a workers' comp on the physical injury issues?
Senator Runner, can I interrupt for a minute? I apologize. My client has to leave. This is kind of.
It's okay.
You okay? Yeah. Okay. This is kind of an emotional thing
sure,
for him to this
sure.
day. That's why the other plaintiff wasn't here.
Yeah.
But in answer to your question, if he would have pursued workers' comp, the first problem with that is the attorney's fees are capped at 12.5% of the recovery. You're not going to get a good trial attorney at 12.5%. In this case, Chris Dolan, and I think a lot of people know who Chris Dolan is a great trial attorney. And he had a 50% attorney's fee provision in his agreement with him. he got 50% of the recovery. If you're going to get a high-powered attorney, you're going to have to pay him 50%. The second thing is, if you go workers' comp, the recovery is limited. So you have to steer away from that because the attorney is counting on 50%, and he's counting on 50% for a big number. The other thing is, for the plaintiffs themselves to get sort of justice out of it, for them to get retribution from a big company like FedEx, the only thing a big company like FedEx understands is a big number.
Right.
So the jury had that in mind, and it wasn't going to happen in a workers'
So
comp.
an individual has to make this decision in regards to whether or not they're going to go down a workers' comp path, knowing that those are the limits that are applied, and the level of representation that they can have.
Exactly.
Or go down this other path then that has to omit the issue of physical injury that took place in the job place.
And this is like the most common
right.
Strategy that plaintiffs' attorneys pursue. Rarely in the last 30 years have I ever seen a workers' comp.
So, but then as this case moves forward then through the court and through the trial, then all of these other physical issues then are brought up.
Exactly. You can argue once a case gets in front of the court, once it moves to the jury, you can argue at trial whatever you want. There's no limit on what you argue for trial.
So then it's a decision in regards to the amount that's awarded or the decision that's made is based upon this pile of testimony and evidence, which then could include the name calling. It could include any kind of cultural remarks, but then would also include any kind of sexual abuse that may have taken place.
Right. And in Chris Dolan's closing arguments to the jury, he says, look, there's been a lot of name calling. There's been discrimination, but that's not what this case is about. It's about the sexual abuse.
Okay.
And he made that clear.
Okay. Let me ask in terms of appeals.
And if I may, my client just added that they spent 14 days of court time in front of the jury talking about sexual abuse.
Okay. Let me just go to appeals real quick. I'm compelled to feel like that this is clearly a portion of physical effect here in terms of this decision. I'm not sure if I would believe that it all is a part of it, but I believe there's a substantial part of it. Let me ask you about allocation. What is our ability to take a look at this and decide that this portion of it would relate to the physical abuse issue and this other part relate to other points of discrimination?
Well, it's a question of fact as to what the payment was for.
Right.
Part of that question of fact can be sort of separating the payments into this amount was for emotional distress, this amount punitive damages, this amount may have been based on personal physical injury. Obviously, in the case of Amos v. Commissioner, which is discussed in here, they did that sort of switch.
So we could determine an allocation on this, which would then separate portions being taxable, portions not being taxable.
That would be part of the finding of facts, correct?
Okay, thank you.
Ms. Dowers?
Yes, thank you. To appellant, I believe during your testimony you indicated that the jury verdict was rejected by your client?
No, the remitter was, both parties filed for a new trial, or at least FedEx filed for a new trial, a judgment NOV, notwithstanding the verdict. And the judge offered a remitter where he knocked down the compensation to $750,000 and the other amount, I forget, maybe $5 million. And that's what the taxpayer rejected.
Okay.
And we rejected that and appealed to the Court of Appeals.
I'm looking at FTB Exhibit C, page 11, and it states plaintiff, which would be the appellant here, plaintiff's consent to the court's remitter. And then it goes on, and the judge states it again. The plaintiffs have advised me that they accept the remitter that I offered. So I'm a little confused. Well, not confused, just seems to be a conflict. You're saying that they rejected it, but this document is saying that they accepted it.
Oh, hold on for a second. Yeah, sorry, I may have misstated that. His recollection is that they did not reject it, they just appealed.
Okay.
Yeah.
May I clarify that?
Yes, FTB.
Yes. The judge's order was to reduce the damage award, and he gave the plaintiffs a certain time period by which to consent to the reduced award. And he said if they did not consent, then he would grant a new trial on damages only. And so that was the plaintiffs did consent to this reduced award rather than having a new trial on damages. And after the judgment was entered, the defendants appealed, and then the plaintiffs filed a cross appeal.
Thank you. To the appellant attorney, what would you say would be the portion? Our appeal staff said that as a finder of fact, we can look to evidence and determine there's some type of allocation. What evidence do you have that would give us the percentage of allocation between physical injury and non-physical injury, emotional distress, and punitive damages?
Yeah, I appreciate your question. On the one hand, if there was physical injury, et cetera, then, you would think that 100% is excludable. But going to Senator Runner's comment about an allocation and, what you're asking me, I have talked to my client about percentages, and we don't have a specific item to tie it to. I know my client would appreciate something in the 70-80% range for physical injury. You can see the physical injury was huge to him. I think he still suffers for some type of post-stress. As you can see, he had a hard time today with this whole thing. So I know he feels, but if you say, what would I tie that to, a 70 or 80% number? See, I don't have anything to tie a percentage like that to. I can't say, well, it's because of this, I would say. I would say because of the suffering he went through, I would look to something like that. But I don't have like something specific to point to and say it's because, tying it back to this number or tying it back to that number. I don't have that.
Okay, thank you. I appreciate that. And this appeals, this clarification, who has the burden of proof here?
Respondent has a presumption of correctness for findings of facts, so appellants have the burden of proof to show what, if any, percentage would be tied to personal physical injury.
Okay, thank you. Thank you, Ms. Ma.
Mr. Horton.
Thank you, Madam Chair. Question of the department, how do you reconcile Amos in this case, if you were called to do so?
Right. The Amos case involved the Amos case is quite an opposite, I think, because in that case involved a taxpayer who was kicked in the groin by a basketball player, and he exhibited, he was limping and complained of pain when he sought medical treatment. And he filed a police report, later settled the matter. Here, unlike Amos, there's no evidence of any physical injuries for which appellant sought medical treatment. There's no police report that was filed. The lawsuit complaint did not allege a claim for assault and battery or physical injuries, and did not identify any physical injuries or for which he sought damages. And therefore, unlike the Amos case, the evidence here does not reveal any physical injuries for which the employer paid appellant settlement, a settlement amount.
What was the period of time of the alleged damages?
In this case, yes, the starting point for the, according to the jury verdicts, they were to consider harassment after January 23rd, 2000. And the judge's order also mentions that date. So it was subsequent to that period. And it was a relatively short period of time.
What was the period, January 23rd?
Beginning after January 23rd, 2000 is the date in the jury special verdict.
Ending when?
Pardon me?
Ending when?
Pardon me?
Ending when?
Oh, there was no ending date, but it was based on the evidence And the evidence seemed to suggest that this went on for several months, this harassment.
Would the appellant like to codify the period in time?
Yeah.
Which this,
So the starting date is the date, like the Franchise Tax Board said. But the period in question went on all the way to trial, so 2006.
Started in 96 too.
But the damage that occurred went over a period of years. And if, twice this medical thing has come up, if I could address that, Mr. Horton?
I don't find the medical an issue.
Okay, good, because, you know, he was so humiliated, he wasn't going to the doctor or
no need
anything. Okay, I apologize.
I mean, from my perspective, indicative of sexual abuse, when the physical component of that is rarely addressed by the person that is suffering. It's a psychological effect that occurs. I certainly appreciate the appellant's view in that regard and how he responded. I appreciate that. The question of the department, in Mascot versus the commissioner, the court said that the trier of fact is to look at the settlement agreement first. And herein, in the settlement agreement, it seems to refer to physical injury, and then to look at the judgment. And the judge seemed to have referred to physical activities towards the appellant, and that the harm is physical rather than economical. And so with those references, in addition, the claim itself made claims. How do you define those terms used by the judge as well as articulated in the claims? I mean, the use of the term physical and harmful environment seems to imply an element of physical abuse.
Not necessarily. I think this was primarily there was emotional distress that resulted from the harassment that the plaintiffs experienced, and that was clearly recognized. But if may I clarify that the judge's statement in his order was that the harm was physical, even though emotional, rather than economic. So in using the term physical, he recognized it was emotional. And he was emphasizing that appellant didn't suffer mere monetary damages or monetary harm, but rather emotional harm that may have had some physical effects. However, the physical symptoms of emotional distress do not constitute physical injury. And this is set forth in the legislative history of the 1996 amendment of Section 104A2.
In the initial judgment, the court awarded $28 in punitive damages against the appellant's manager for involved in punching and pushing the appellant. So it appears that in the initial judgment, even though a nominal amount, there appears to be an acknowledgement that the physical activity alleged by the appellant existed, which would cause one to believe that there was evidence during the trial of some physical activity, as so stipulated in the documents provided by the appellant, but yet not really challenged. So there doesn't appear to be any disagreement that the physical activity took place. Now, whether or not the court awarded that is debatable. There seems to be some evidence that the court thought so. But let me take us to the environment subsequent to the court. We're in more of an environment of an appeal. We're in an environment where all things are up for grab. And you're going towards a settlement. So all of a sudden, all of the issues that were in the original claim of physical abuse are now surfacing again for consideration in the settlement environment. How do you reconcile all of that?
Well, this was in the context of an appeal. May I clarify the basis for the punitive damages award?
Sure.
That the jury verdict specifically was, the jury special verdict specifically stated that the jury found a manager engaged in wrongful conduct with malice or oppression, and the company officers knew of this and yet retained him with knowing disregard for the rights of others. And so, there's no indication that any kind of physical element was involved in the punitive damages awards. The judge's order, the remitted order, specifically stated that the basis for the large punitive damage award was because the employer's witnesses, had lied, and he specifically mentioned that, and it was because the jury saw this that they awarded the large damage amount. But there's no indication anywhere that physical injury was a consideration in awarding punitive damages.
I think, go back to your question about what the settlement was for. Courts typically ask, what is a settlement being paid in lieu of? What's it for? And so the appellant had a $6 million award for emotional distress for non-physical claims, and so the settlement was based on that award that he'd already won on, and so that's the best evidence of what it was for. And so, the award was based on non-physical claims. There may have been physical contact, but the award itself, which was settled, was based on non-physical claims.
And I didn't answer your question about the appeal status at the time of the settlement, but once an appeal was filed, the parties are limited, in terms of the issues that would be viable issues in an appeal. And very clearly, the jury had only found the defendants liable for 2 claims: racial harassment and failure to take steps to prevent the harassment. It's very unlikely that any other claims can be raised on appeal, because it's very difficult to overcome the evidentiary level that's required to do that. And so on appeal, those were the main issues that would have been addressed, the issues that the jury had awarded the appellant damages for: racial harassment and failure to take steps to prevent the harassment.
I do a certain amount of state trial work, and none of what she said is true. On appeal, I can raise any issue that came up in the trial. I can talk about the judge and how he ruled on certain things. You stated it correctly. So I'm not sure what the citation is for that. But my experience is similar to yours.
I was just saying that based on what occurred in the trial, the plaintiffs could try to resurrect other claims that they had filed in the complaint. But again, none of the claims in the complaint were for physical injuries or physical sickness, and therefore, it's very unlikely that they would have raised these as issues in the appeal. And the judge, in submitting only 3 claims to the jury, had determined that there was sufficient evidence for only these 3 claims: racial harassment, retaliation, and failure to take steps to prevent the harassment.
Yeah. The inherent challenge before us has been discussed in the courts on a number of occasions, and that is distinguishing physical harm as something that has to be a broken leg or bodily injury. And so, if my recollection is correct, courts have consistently said that pushing, punching, even though no apparent physical harm, and combined with the physical, with the mental, emotional abuse, is an element of physical abuse. So, and over such a long period of time, one would presume that there's some element of physical abuse here. Now, the question becomes whether or not the settlement agreement incorporated that, and whether or not Amos is instructional to the trier of fact as to how to go about measuring them. So that takes me to the appellant, and without some level of evidence to measure that, is there any direction you give?
And I've thought about this quite a bit, and if we're looking at some evidence that we have on the table, we have the settlement agreement on the table. And if we look at the settlement agreement...
Well, I believe the settlement agreement has an element of self-serving as well.
Well,
even though I do believe there's a measure there, and quite frankly,
was mischaracterized. The settlement agreement was mischaracterized by the Franchise Tax Board. It was through the parties appealed, they sat down with a mediator, and through mediation, they hammered out their agreement. FedEx has no reason to admit to physical abuse or even let it in. I mean, if I was the attorney for FedEx, I would never let it go into the agreement. It would have just been a flat out. They were forced into it somehow. I wasn't there. I can't testify as to what actually happened, but no big corporation voluntarily lets that into agreement unless they're forced to. So if we look at Section 2 of the settlement agreement, there are sort of three items that they're talking about. They're talking about emotional distress, and they're talking about emotional distress attendant to alleged physical injury. And if we say physical injury coupled with emotional distress is excludable, and we say emotional distress standing alone is not, then we can say of these three items, 1/3 is excludable. 2/3 is excludable. 2/3 is excludable, 1/3 is not. And then we could end up with a 2/3, 1/3 allocation based on the evidence of the settlement agreement.
Mr. Horton.
Did I confuse somebody?
No, you didn't confuse me at all.
Ms. Dowers.
Can you state that again, looking at, you're saying there's three items?
Yeah, I looked at three items. I said allegations of emotional stress, comma, including emotional stress attendant to alleged physical injury. And we know under 104A2, if it's emotional distress coupled with physical injury, that much is excludable. Okay? Emotional distress standing on its own is not excludable. Okay? You have to pay tax on that. So if we say there's three items and we allocate 1/3, 1/3, 1/3, then the emotional distress coupled with alleged physical injury is excludable. That 2/3 is excludable. And then emotional distress standing on its own, the 1/3, is taxable. And that would give us a 66 and what is 0.667 exclusion and a 33.334 taxable element based on the evidence we have.
Oh, man.
I could do that in reverse.
Madam Chair.
Mr. Horton.
Question of the appellant. I'm not really asking for any details necessarily, and certainly don't want to have you relive anything. Subsequent to this, have you experienced any panic attacks, any suffering, any anxiety that has caused you to seek medical attention?
You're asking me, right?
No, I'm directing.
Well, you can answer for them, I think.
It's entirely up to you whether you want.
Good morning. Believe me, I don't want to be here. I've lived this we're in court for almost 2 months. We spent 3 weeks just on physical assault, and for somebody telling me suck my cock. He admitted to it. It's really hard to be here, but it was so hard for me to seek any medical treatment, going to a doctor, the manager is telling me to suck my cock. And although I'm Christian, but also cultural belief, it was against my belief.
Okay. All right. Thank you, Madam Chair.
Any other comments? I tend to agree with all of my colleagues here. This case is obviously very complicated. It's harassment, it's failure to protect employees, sexual abuse, emotional distress, physical injuries, trauma on a prolonged basis in a hostile environment. It's not clear-cut. I agree with my colleagues that perhaps some sort of allocation should be made, and I think we may be just stuck on the number. And I don't know if someone wants to put out a motion or...
Madam Chair, if I may, to that end, I'm going to ask this question again of the department. Almost. How do you reconcile the almost case to this case?
Well, in that case, the taxpayer was kicked in the groin, and he, which is very obviously a physical injury, and he had pain and, was limping when he went to seek medical attention. Here, there's no evidence of, anything comparable to that, and he also filed a police report. There's no evidence here of a police report. And it's quite a different situation when, based on all of the court documents, the complaint, the jury verdicts, the court's order, remediator, no mention of any kind of physical injury at all. And so it's, I think that Amos case is quite different.
And so how would you distinguish a kick in the groin to punching and pushing and sexual contact, physical contact of any nature? I mean, then it kind of goes to a jury trial to kind of measure, distinguish that. I don't want to necessarily, burden us with that.
The claim that was submitted to the jury was harassment based on race or national origin, and the judge specifically stated there was offensive name-calling that was rampant, and that was the primary basis for the harassment. There's no indication of even sexual harassment, being submitted to the jury. And so there's no indication that there was the sufficient evidence of that to be submitted to the jury.
All right. Thank you, Madam Chair.
Ms. Harkey.
Thank you. I am not a male, as you all know. But I can tell you if somebody grabbed and groped me in my personal spots, it would hurt. It might not bruise. It might not show up. I might not go to the doctor for it, but it would hurt. Now, I have heard that the male body is a little bit different and that it definitely hurts. And I'm not so sure that that would show up or that anyone would go to the doctor for it. But I do find that groping personal genitalia is physical. And we have had to hear a lot of testimony here that I wished we hadn't have heard, but I think we have to get down to what it is. And so just because there's not a scar or a mark doesn't mean that somebody is not injured or did not suffer pain. And I believe in reading the testimony was very clear that there was physical contact in personal private areas, and that it was not well received nor appreciated, and it was on numerous occasions. Breaking it down as to what goes to what, I'm open to suggestions. I don't believe that 66% is the number. I think maybe a 33 or 33 and whatever, 66, maybe reverse that. But I would be willing even to submit that a 50-50 might do it for me. But I definitely do not want to see that there is no relief at all for physical injury, because I believe the settlement agreement set that out. I do believe that it was in the transcripts. If you read the transcripts, it was obvious. I think that the reason that it wasn't tried is for the workers' comp issue, and I think that probably makes sense. But I think that coming this far along, this is 2006, 2007, and we're still reliving this, I would have hoped we'd had a little bit of a consideration. I would be willing to throw out a motion for a 33 and a third not taxable, 66% taxable.
Second.
Mr. Runner.
Yeah, I think, I mean, this is like trying to figure out where the middle is, isn't it?
250.
I'm actually better with 50-50 personally.
I withdraw my motion.
And I'll tell you why I get there. You know, the fact that I get the fact that the claim itself didn't include these things, but I also get why, right? I get why they couldn't, because the lawsuit wasn't based upon those issues. Otherwise, it would have gone a workers' comp claim. So I'm not motivated by, you know, the FTB's justification. We'll say, you know, this was what was given to the jury. This is what they decided on. My understanding from reading the transcript is that may be what the judge had given them, but the fact is, much of the testimony that was given to the jury included these physical and sexual issues. And to me, that's what then, in my mind, created a large settlement, or a large jury award, and then ended up with a settlement. So to me, that's what colored the whole thing. So, and I have a hard time trying to figure out where the line is. But I got to believe in my head, I think, in my gut, I guess, is that the things that hurt the most weren't necessarily some of the name calling and some of the ethnic issues. I got to believe some of the issues that, from what I hear and hear from other folks, it's the inappropriate sexual advances. It's the demeaning sexual issues. It's all those issues that, to me, create then the abuse that I see here, that I think is a physical abuse when it comes to the issue of that. So I would. You withdraw your motion?
We have a motion, if you want to offer.
Let me a substitute motion for a 50-50 split.
Is there a second?
Can I have a comment first?
Discussion? Ms. Mars?
Man, I understand what you're saying, Mr. Runner, that there is some emotional distress, there is some physical injury, but I was at the 33% because I'm looking at the settlement agreement where I see them saying emotional distress and emotional distress for the alleged physical injury, and that's a 50-50 by itself. But I'm also looking at all the other evidence and the fact that there was punitive damages initially, and punitive damages are not excludable. And reading the documentation and the judge comments, it's clear to me that the punitive damages was taken, the jury heard all the testimony of the abuse, and that's why the punitive damages was so high. And that's why I cannot just dismiss the punitive damage portion. Mm-hmm. So I was more at a 1/3 across the board.
Yeah.
Discussion, Mr. Ward?
Madam Chair, I would agree with Member Stowar. The evidence being the initial claim, the decision by the courts, and the subsequent settlement agreements, and the discussion here by the appellant seems to draw a distinction between these items. The concerning factor here is that this is an environment over a long period of time with continuous activity. So when you connect that to physical, whether it's certainly, I do not believe it needs to rise to the level of kicking or anything of that nature, but touching is physical abuse inappropriately. And so to have that environment over years and have it to be continuous over a period of time, logic would dictate that there is some elevation over that period of time to a touching physical. To what degree that is, I don't know. The judge and the jury seem to be clear that the initial phase of the majority of the activity was some verbal abuse. But they also seemed to be clear that it was an environment of physical to draw a connection to the two inherently. The judge said mostly, so I would tend to believe that the majority was actually on the side of the verbal attacks over a long period of time, connected to some element of physical at some period of time, and would concur with Member Harkey as well as Member Stovall that that would be, in the absence of any other number, 33% seems to be more than reasonable based on the facts, the law, and the various cases.
Okay, sensing the members' comments, can maybe Ms.
I think we go back to.
Harkey will go back to our original motion?
Second. There was no second, so we're back.
I thought there was a second. There was a second by Ms. Stowers?
No, second on mine.
No,
I said
No.
So we're back on.
Right.
Thank you.
Okay, do we have to make another motion, or back to the original motion? Okay, so the original motion by Ms. Harkey, seconded by Ms. Stowers, is 33.33% is not taxable, 66.67% is taxable. Okay, members, without objection, motion carries. Thank you, Mr. Montine, thank you, Mr. Issa, thank you, Franchise Tax Board and Appeals.
If you could, Madam Chair, for clarification, does that also mean that the late filing penalty will not be abated, but will be calculated based on this finding? And
excuse me, can you say it again?
Sorry, there were a couple other issues that were on appeal.
Late filing penalty.
Late
I'd
filing
like to
penalty.
abate the late filing penalty.
Thank you.
Second.
Objection.
Oh, objection, okay, let's take a roll call on, let's take a roll call on abating the late filing penalty.
Chairwoman Ma,
Yes, aye.
Ms. Harkey,
Aye.
Mr. Horton,
No.
Mr. Runner,
Aye.
Ms. Stowers.
No.
Motion carries.
Any other issues, Mr. Johnson?
Appellants had raised that they may be entitled to additional attorney's costs and fees, but that wasn't discussed any further.
If I could address that.
Okay, Mr. Montine.
That was preventative. I have been, I'm sorry, I only raised that in my pleadings as preventative because I've been blindsided before with new sort of matter popping up. So I can withdraw that or put that aside.
Okay.
Okay, so no action on the attorney's fees and costs? No deductibility?
No,
Madam Chair.
it's not an issue.
It's not an issue.
Mr. Horton?
Madam Chair, I would ask the department that they also agree with that.
With what?
Well, the attorney's fees, yes.
Oh, yes.
We agree.
All right.
Thank you.
Okay, so
I think
we dispense with all issues?
Yes.
Okay, thank you very much. Thank you all.
Thank you very much, everybody.
Thank you. Let's take a quick break. Yeah.
Okay, can we just take a quick 5-minute break, and we will be back to start our next case.
Somebody raise their hand if they're working on this. I think they're in the back room back there.
They should see us.
There we go.
Our mics aren't on?
Testing, okay. We are back live on the live stream. Can you test your mics? Mics? No? Still? Microphones are not on yet? Flip the switch. Okay, microphones should be on. There we go.
All going.
Okay, Ms. Richmond.
So our next item is item C, Sales and Use Tax Appeals Hearings. We have a local tax reallocation hearing. Item C2, cities of Ontario, Palm Springs, San Diego, Santa Barbara, and counties of Sacramento and San Mateo. Please come forward. This case was granted an additional time, 14 minutes for the opening presentation and 11 minutes on rebuttal.
Okay, two appeals. Will you please introduce yourself and the issues in the case?
Chairwoman Ma, members, good morning. I'm Tricia Nino from the Appeals Division, here along with David Levine. The primary issue is whether the local tax that was directly allocated to the Oakland office, where the orders were received, should be reallocated to petitioners. If so, then the next issue would be whether all petitioners meet the $500,000 threshold for direct allocation. As a reminder to the hearing participants, because the taxpayer is not a party to this appeal, confidential information regarding the taxpayer must not be publicly disclosed. That includes the identity of the taxpayer or any other information which could easily identify the taxpayer. In addition, this is an appeal that is covered by Revenue and Taxation Code Section 40 and thus requires a public decision. Thank you.
Thank you, Ms. Nino. To the petitioners, welcome to the Board of Equalization. You've been granted additional time for your presentation and rebuttal. Collectively, you will have 14 minutes to make your initial presentation, and we'll have an additional 11 minutes on the rebuttal. Please introduce yourself for the record.
Thank you, Chairwoman Ma and members of the board. My name is Eric Myers. I am an attorney for and employee of Muni Services, which is the sales tax consultant for the cities of San Diego, Ontario, Palm Springs, and Santa Barbara, and the county of Sacramento in this matter. We're referred to typically in the documents as the petitioners. With me today is Matt Vespi, the Deputy Director of Financial Management for the city of San Diego. And Paul Prather, who's seated in the audience and available if we have questions for him. He's the Deputy City Attorney for the City of San Diego. Mr. Vespi has prepared some remarks, which I will ask him to deliver in just a few moments. And Mr. Prather may also have some comments. So I may be playing a bit of musical chairs here. Oh, looks like we've freed up another spot. That's great. Seated to the left of Mr. Vespi is Mr. Brian Wong, Deputy County Counsel for the County of San Mateo. When we've completed our brief opening statements and comments, we will turn the balance of our time over to Mr. Wong. We've tried to coordinate our presentations to minimize redundancies today. The key question presented to the board is this: were Ms. M's activities in the Oakland office participation in the sales between the parent and the taxpayer? Now, this question has several parts, and I'll address each briefly as we've discussed them in detail in our submissions. The first is that the relevant universe of discourse here is the transactions between the parent and the taxpayer. Whatever else Ms. M may have done, either in furthering the business in general or in dealing with other customers, are not actually at issue in this case. The taxable transactions in this case are between the taxpayer and the parent, and that's what's at issue here. The second is that what we need to be looking for is the selling at retail, not necessarily activities that advance the general business that the taxpayer or the taxpayer was in. And then finally, sort of say, stripped to its bones, the question becomes whether Ms. M's receipt of estimates, called variously purchase orders or nominations in the documentation, whether her receipt of estimates constituted order taking, and it did not. There were a series of successive estimates, and there was no obligation for the parent to purchase the amount stated in its estimate. The amount actually purchased happened when fuel was loaded. We acknowledge that the estimates may have been useful for planning and inventory purposes, that they may have even been vital for general business purposes, as they would be for any retail establishment, to make sure they have inventory to sell. But they were not orders. They were estimates. Thank you for the opportunity to address you today, and I'll turn some time over to Mr. Vespi now.
Thank you. Good morning, Chairwoman, members of the board. As Eric mentioned, my name is Matthew Vespi. I'm Deputy Director of Financial Management for the City of San Diego. The City of San Diego has a track record of using economic development agreements in a responsible manner to retain local businesses and help them expand, creating new jobs and better opportunity for the city's residents. The City of San Diego does not use economic development agreements to attract businesses to relocate and, as a result, poach sales tax revenues from other jurisdictions. As you are aware, in this case, an economic development agreement was used to incentivize the taxpayer to begin reporting all California jet fuel sales to the City of Oakland in exchange for a rebate of 65% of the sales tax. As described by Mr. Myers, the City of San Diego strongly believes the taxpayers' activities in Oakland were not sufficient to create participation in the sales in question and thus move the point of sales and resulting sales tax away from San Diego to the City of Oakland. Additionally, as previously noted, the main function of the taxpayers' Oakland location was to estimate jet fuel inventories, not place actual orders for jet fuel. While estimating fuel inventories is an important business function, it does not create participation in the sale. The sales tax liability for the transactions in question was created when the actual number of gallons pumped and the actual spot price of the fuel was known. Both of these were determined at the San Diego airport when the fuel was actually pumped into the plane. No sales tax liability was created by the taxpayer estimating future fuel needs from the Oakland office. Furthermore, there was no change in the level of service the City of San Diego was required to provide to the airport or to the taxpayer during this period of time because there was no change in the taxpayer's operation in the City of San Diego. The City of San Diego had the same financial obligations, although the city's sales tax receipts had been reduced. Again, thank you for your time, and I'll turn it over to Mr. Wong to complete our comments. Thank you.
Good morning, Chairwoman Ma, members of the board. My name is Brian Wong. I'm a Deputy County Counsel in the County Counsel's Office in San Mateo County. I represent the county, which is one of the petitioners in this matter. The county joins in the comments that Mr. Myers has made with respect to participation. And like Mr. Vespi, Vespi City, San Diego, San Mateo County hosts a large international airport that bears a number of costs associated with the presence of that airport inside its borders. In addition to the issue of participation, I would like to make a couple comments with respect to AB 451, which, as many of the members know, was legislation that was passed in 2006 but was operative in 2008. AB 451 introduced amendments to Revenue and Taxation Code sections 7204.03 and 7205, and those amendments made the types of arrangements that are at issue before the board today not allowed. So it wouldn't allow tax money to move from airport jurisdictions to non-airport jurisdictions, or to other jurisdictions outside. I guess I'd start with saying that we agreed with the Appeals Division with respect to AB 451 and its amendments, and that AB 451 is simply irrelevant to the decision with respect to the appeal here today. This is true for several reasons. The first is if you look specifically at the amendments contained in AB 451, they're unambiguous. If you look actually at the line comparison, it simply deleted a line from the existing statute. That line was, the retailer has more than one place of business in the state. And that change was meant to effectuate sort of the change to not allow these arrangements to move the tax to a different jurisdiction. When a statute is clear in that way, there's no need to go looking around for further understanding or further meaning. You look at the statute is clear, and that is how we should be determining what the legislature intended by passing those amendments. Second, looking at the legislative history, to the extent that there are comments in there with respect to a, quote, Oakland agreement being contrary to the intent of the existing law, yet technically legal, those are from the summary reports prepared by a legislative analyst that summarize, kind of for context purposes, the situation into which these amendments are going into. It's not from the bill's sponsor. It's not from a legislator. It's from an analyst who's attempting to summarize. Third, and perhaps most importantly, even if portions of the legislative history were informative as to the legislature's intent, it's clear from looking at the legislative history that it was not looking at the specific details and facts that are before this board today. If you look at the text of the reports, it's talking about a Oakland agreement being technically legal. It doesn't speak to the types of participation and other items that will likely be a source of discussion today. I think I'd want to emphasize that what is important is what actually occurred in Oakland, as opposed to what technically could have happened there that would have complied with the existing law. I think I'd reiterate at this point what the supplemental decision recommendation had to say about AB 451, which is that it set forth what the law was going to be going forward, but it did not interpret the existing law that was in place during the time period in question here, which is 2004 to 2008, nor did it approve a particular interpretation of that law, which would be saying that the arrangements that are issued today were somehow, in fact, complying and allowed by the law at the time. I'd like to reserve any balance of time I have for a rebuttal at this point. Thank you.
Thank you very much. Okay, we'll now go to the department for their presentation. You'll have 10 minutes to make your presentation. We'll return to the appellant for rebuttal. Please introduce yourselves for the record.
I'm going to let the City of Oakland go first, and then we'll follow them.
Okay.
Good morning, Chairman Ma and members of the board. I'm Chris Key. I'm appearing on behalf of the substantially affected party, City of Oakland. Let me say, just as a threshold matter, on behalf of the city, to extend my gratitude for the opportunity to present our case and to appear before you this morning. After proceedings stretching over 8 years, 2 appeals conferences, some 2,000 pages of documentary evidence, live testimony for a matter of hours, sworn declarations under penalty of perjury, multiple extensive briefing, this matter has come down to a single question, and that was, did the taxpayer's Oakland office participate in any way in sales transactions of jet fuel such that local tax under Bradley Burns was properly allocated to the City of Oakland? Both the department and the appeals division agree that the answer to that question is yes. Using Regulation 1620's language as the measure, it is abundantly clear that the activities of the Oakland office constitute participation in any way in the transactions by which jet fuel is sold as a matter of industry practice. What the record shows is that there was a real office staffed by a real person engaged in the real business of selling jet fuel to taxpayers' customers, which included its corporate parent and multiple third-party customers. I must take issue with Mr. Meyer's representation that this matter is only related to sales between the taxpayer and the parent. The record actually shows that the dealings with third-party customers was a primary profit driver at points during the time period that we're talking about here. The office was staffed full-time by a woman of considerable accomplishments, whom I believe that we are referring to as Ms. M for these proceedings. She was highly regarded, much awarded former manager of the corporate parents database group, and she was the essential participant in these sales transactions. As the record makes clear, in the jet fuel industry, there is a process by which sales are consummated, an increasingly precise series of transactions culminating in a final nomination, which is the industry's term for a purchase order for fuel. These were not estimates, these were not mere estimates for the purpose of stocking the shelves, as it were. These are, as the supplemental DNR recognizes, these were purchase orders that were, in essence, requirements contracts, specific orders from specific customers to be filled at a specific airport for as specific amount of fuel as was possible for the customer to project. It was Ms. M's job to receive and process those orders and then arrange for delivery so that there would be sufficient fuel to meet the customer's requirements when their planes actually pulled up to the pump. The record shows that there was, in fact, no agreement. There could be no sale unless and until these purchase orders, signed purchase orders, were received by Ms. M at the Oakland office. So far from being, as Mr. Myers suggested, a mere estimate, it was an indispensable, perhaps the indispensable component of the sales transaction. And because these transactions took place in a volatile commodities market, it was also Ms. M's job to ensure that once the customer's requirements were met, that the taxpayer itself would be left with as little uncommitted fuel on hand as possible, which also reinforces the correct understanding that this was not building inventory. Excess inventory was, in fact, anathema to both parties for a number of reasons. It was expensive for the carrier to have excess fuel on board when they flew, and it was an economic risk on the part of the taxpayer to have more fuel on hand than was necessary to meet the requirements of its customers. Petitioners, particularly in their briefing, tell an entirely different story, which was based on the underlying premise that the Oakland office was illegitimate from the very beginning and that these entire endeavors were an elaborate scam. I would submit, in light of the record, the full record that is now before the court, that underlying premise is difficult to sustain. What petitioners really ask of this board is to effectively undo the legislative compromise that resulted in the passage of AB 451. That compromise, which did affirm that as a threshold matter, the Oakland office was legal under then existing law, created a settled expectation on the part of the city of Oakland that local allocation of sales tax from sales consummated at the Oakland office would continue until January 1st, 2008. Having lost that battle in the legislature, petitioners now want this board to do what the legislature and the governor did not and would not do. In light of Oakland's settled expectations, I would respectfully urge the board to also consider the real-life consequences of what petitioners hope to accomplish here, which is to claw back nearly $13 million allocated to the city of Oakland over 10 years ago, revenues that have long since been spent for the benefit of the citizens of the city of Oakland. Oakland is only now emerging from the crushing effects of the Great Recession and as a former employee of the city, I can speak from personal experience about how things were in those times. There were mandatory furloughs, there were layoffs, there was uncertainty, there were tough choices between infrastructure management and public safety. Affirming the conclusions of the department and the appeals division thus has the triple benefit of being the correct legal result on this record. It reaffirms the will and considered judgment of the legislature, and it is fundamentally fair. And so, for all these reasons, I urge the board to deny the petitions, and I'll gladly yield the microphone to my colleague here.
Thanks. Good morning, Chairwoman Ma, members of the board. I'm Scott Claremont from the legal department. With me are Robert Tucker and Kevin Hanks, also representing the department, and will be presenting the position of the department in this matter. We concur with the recommendation of the appeals division that that the petition should be for reallocation of local tax should be denied. Taxpayer is a seller of aviation fuel, with many of its sales during the period of issue being made to its parent company under a master requirements contract. It is undisputed that the sales took place in California. Therefore, pursuant to Regulation 1620 and 1802, if a California location of the taxpayer participated in the sales would be allocated to that participating location. If no location of the taxpayer participated in the sales, then the applicable tax would be use tax, and the use tax would be allocated to the jurisdiction of first functional use. Participation in a sale includes any activity serving some real purpose in the actual sales process and involving some genuine physical interaction with the sale. Here, the evidence shows that the retailer established an office in Oakland staffed by a single employee whose main responsibility was to negotiate the acquisition of fuel in order to balance supply with the orders received from taxpayers' customers. And again, in large part to its parent company. To that end, and pursuant to the master contracts, the employee would receive purchase orders from parent on a monthly basis stating its approximate fuel needs for the subsequent month. According to the terms of the contract, these purchase orders constituted an unequivocal and unconditional offer to purchase by parent. The employee's receipt of these purchase orders and her related activities, including managing fuel inventories, confirming deliveries, and addressing fuel shortages, constituted participation in the sale. Since this is the only location of the taxpayer that participated in the sale, we concur that the allocation should go to that jurisdiction, City of Oakland. Thank you.
Okay,
And
thank you.
Madam
if we had-
Chairwoman,
oh, sorry.
if I have some additional time, with the court's indulgence.
How much time do we have? 2 minutes.
Let me address very briefly in more detail the assertions about the estimates. There is an exhibit 3 of the supplemental DNR is a declaration from Ms. H., who is was Ms. M's primary contact at the parent company. And in it, she describes in considerable detail what went into the nomination. She says that she used a dedicated computer program called the BRIO program, which would take into account known passenger load, taxi time, known cargo weights, flight schedule, and gallons of fuel consumed on the flight. The program would consolidate those numbers. Ms. H. would then compare that calculation to the year's estimated and actual consumption of fuel, and then manually adjust it for cancellations and weather at the specific airports. Only after she had done all those calculations would she submit the nomination to Ms. M. So the notion that this was some sort of rough guess about what a customer might need is, I think, fairly thoroughly rebutted by the record. There's also testimony from Mr. S., who was the general manager for the parent company as well.
Okay, we have Miss S, Miss M, and Mr. S. Okay, so thank you very much, Mr. Key. We will now return to the petitioner for rebuttal. You have 5 minutes for your rebuttal.
Excuse me, Ms. Ma, they had additional time granted for rebuttal.
Okay. How much time?
11 minutes.
11 minutes on rebuttal.
Thank you. It is really quite an interesting question that this case poses. Mr. Key has quite eloquently spoken to the fact that they tried very hard to make this look like an order, that in fact they called it a purchase order. But you have to go through quite a bit of mental gymnastics to call this an order in any common sense meaning of that word. For example, there's been much noted that the estimates were well thought out. Well, that's great. They were well thought out estimates, and I'm sure that was helpful to the business. But a well thought out estimate does not constitute an order. There's no obligation to buy the amount in the estimate. The amount invoiced, the amount to which the tax applied, was the amount actually loaded onto the plane, no matter how good the estimate was. The estimate was not the amount that resulted in either tax liability or the sale. It was the actual upload of the fuel to the plane. Furthermore, I think there's a little bit of uncertainty even in the record about there was a 30-day estimate and then a 10-day estimate. We have in the contracts at issue actually a requirement that the taxpayer provide the seller with a purchase order. I'm quoting from Exhibit 3 of the original DNR, page 9. For all California purchases pursuant to a requirements agreement, at least 30 days prior to the beginning of each month, Seller shall provide to buyer a purchase order requesting buyer's approximate jet fuel requirements. And that would be for the subsequent 1-month period, subject to the terms and provisions of the agreement, not later than 10 days upon receipt of the purchase order. So that would be the parent having received the purchase order from the taxpayer. Buyer shall place its order for the jet fuel by submitting to seller a signed and completed purchase order at the location specified above. But even that procedure wasn't followed. The testimony from Mr. S. was that there was a 30-day estimate provided and a 10-day estimate provided, when if you actually look here, should have come in about 20 days. It doesn't matter that much to me per se whether they followed the contract exactly or not. The point is that the contract doesn't actually establish a binding obligation. They didn't treat it that way. They gave an estimate, then they refined it, and then at the airport they uploaded the fuel. Mr. Wong, I believe you had some comments on rebuttal?
It's on 451.
No.
To briefly address some of Mr. Key's comments on the legislation, I think I'd want to again highlight that we are looking at what actually happened in Oakland and whether that could have been something the legislature would have even looked at. I think one specific example indicating that wasn't the case is if you look at the legislative history, I believe it's in the April 11th, 2005 report, when it's describing the existing law, it specifically states that the sales tax revenue is allocated to the jurisdiction where the negotiations take place. And I'd like to point out that looking at the supplemental decision and recommendation, as well as the record here, I think it's pretty clear that the negotiations with respect to the actual sales we're talking about here didn't occur there. I think that's pretty clear from the record. And so to the extent that there is a claim that the legislature was looking at what exactly was going on at the Oakland office and saying somehow that this is fine, we're going to allow that to continue for 2 more years, that's taking it far, far more than what's even suggested in the legislative history.
Thank you. I think one final thought would be, and we take very seriously Mr. Key's statement about the real-life consequences. I've been in front of this board a number of times in the past. Our company works with a lot of cities and local jurisdictions. No one likes to ask a city to pay back money that it received. That's not an easy thing to do. And certainly we feel for the city of Oakland if they interpreted the legislation as meaning something that it did not mean, which was that its process was somehow blessed in the interim 2 years, without regard to what the actual rules say about participation. I'm sure that they must feel frustrated by that. But we're not experts in how this thing would come to pass. We have seen in the past that the board has the authority to stretch out payment plans and do things over time to mitigate impact. Who knows, and I don't know, and so I'm purely speculating, and Mr. Key can call me on the carpet for it. Whether the city could get anything back from the taxpayer, I simply don't know. But we do feel for them. On the flip side, if we were entitled to the money, it's been a lot of years where we didn't have the money either. And so there's, I think, some equities on both sides. Many cities were impacted by the Great Recession. So I would just add that as an additional thought. Thank you, Chairwoman Ma.
Okay, thank you. Members, discussion? Ms. Harkey.
I always start them out. I shouldn't do this, but I do. As I see, we've got 2 issues here. Is it sales tax or is it use tax? Now, sales tax would be allocated to Oakland. Use tax is allocated to the local jurisdiction. So the question for Mr. Key. For the majority of time in question, it is my understanding that the taxpayer had the same employee working in Oakland.
That is correct.
Okay. What were the employee's duties, and what actions did they perform?
Well, as I described earlier, one of her principal goals was the processing of these purchase orders in the manner in which I described, that the parent or the third party would submit these nominations to Ms. M, who would then receive them and process them. And an integral part of the processing was to arrange with the suppliers that there would be sufficient fuel at the various airports to meet the specific requirements. So she was matching the purchase order supplies to the purchase orders in as precise a manner as she could. There is in the record a performance evaluation which describes what she did, and if you'd like, let me read it to you. This is from her 2005 performance evaluation. Processed spot deals, creating the contracts, sending confirmation, approving broker invoices, and setting delivery dates and location. Also created and modified term contracts with Morgan Stanley, Mesa, Air Wisconsin, and SkyWest at SFO and LAX. Worked with, and then there's a litany of airports to resolve fueling issues, such as answering questions about invoices or processes, following up on audit issues, sending current copies of contracts, and looking into tax refunds. She followed up on into-plane overcharge at San Jose Airport for $14,464 in credit, an average $2,000 a month reduction in charges. Going forward, she led an effort to create standard into-plane and GSE templates and minimum insurance requirements for large and small stations. It says this exercise has gotten into all areas to define their requirements and ensures that these will be included in every contract going forward. It also makes contract negotiations much more efficient since only changes need review and approval. Among her other tasks was she was deemed the deal maker with respect to what has been.
Don't name companies or anything.
I'm sorry. What were called proposed term sales contracts, which was the internal process by which contracts were generated. She was the deal maker for these, as is shown in the record, and she would negotiate the terms for instance, a location agreement, which is another industry-specific term for an agreement that would set the general terms on a longer-term basis for the fuel that would be acquired. For instance, it would set pricing and the type of fuel and the manner in which it would be delivered into the planes at the airports. Ms. M negotiated those contracts, and so she would generate the proposed term sales. Those would get passed through the company hierarchy for approval. If it was above her ability to sign, there was a monetary cap set on the amount that an employee could sign. So she would circulate these through the corporate structure, and then the contract would be generated on the basis of terms that she had negotiated with respect to, for instance, these location agreements. She did arrangements with suppliers on the price of fuel, as well as for arranging for delivery, as I was mentioning earlier. So for instance, if there was a specific requirement and there was not enough fuel available at the location, she would make the specific arrangements with the supplier to make sure there was enough fuel on hand. She would truck it in if necessary. So that was the degree to which she would go to work with the suppliers to make sure, once again, that there was sufficient fuel to meet the requirements of these purchase orders. I could go on, but this gives you a general sense of what she did.
Thank you. For the department, what constitutes participation in sales?
Again, the standard we look at is, and it says any form of participation, so we look at any activity serving some real purpose in the actual sales process and involving some genuine physical interaction. So we think the taking of the purchase orders and then arranging for supply in response to that is both something that has an effect on the sale, and it's also, there's the physical interaction with the seller, the purchaser in this case, is the receiving of the orders.
Okay, this is for the petitioner. Can you explain why you believe this is not participation in the sale?
Sure. The participation in the sale is an undefined term. The standard just quoted to you by the department exists nowhere in law. It is a decent standard that was put forward in the SDNR with a slight change from the original decision and recommendation. We think that 1620A2A can't possibly mean what it says, which is in any way. For example, if we take that literally, and we follow, say, a line of reasoning that Mr. Key has advanced, the payroll office is participating in a sale because the payroll office pays the people who do the selling, and no one has consistently argued that the payroll office is a place of sale. So we think that this rule has to be read with a reasonable limitation in mind, and that is it's sort of directly involved in the selling. Now, again, the selling of what? Here, the issue is the sales between the taxpayer and the parent. And despite all of the wonderful things that Mr. Key has just read that Ms. M did, it's acknowledged in the record she didn't negotiate the master contracts between taxpayer and parent. She didn't negotiate the location agreements between taxpayer and parent. What she did, and I'm quoting now from paragraph 18 of her own declaration, it's Exhibit 2 to the supplemental decision and recommendation. As mentioned above, however, the most important part of my job was to manage, on an ongoing basis, the balance between purchases and supplies of fuel at the various airports under my responsibility. She managed inventory. Incredibly important for any retailer. Please don't get me wrong. We're not arguing that that's not an important business activity. It isn't sales activity. It isn't the receiving of an order. I want 5 shirts today. Okay? She received estimates. Hey, we're probably going to order this much. Our planes are looking like this. Please make sure you have enough on hand that when we show up, there's enough inventory for us to fuel our planes. That isn't participation because it isn't order taking. Now, if the question is it some other form of participation that hasn't been defined yet? We don't think so because it's so broad. That interpretation to reach Oakland's position is so broad that it allows in all sorts of activities that are related as business activities, that but for those activities there wouldn't be a business, but that aren't selling at retail.
Okay, I understand your point. I'm having difficulty, well, one of the things you said is that, doing payroll, but I believe Regulation 1620 states that participation in the transaction anyway, be the local office, branch, or outlet, or other place of business, is sufficient to sustain the sales tax. And that says, also goes on to include a California business location of the retailer serving some real purpose in the actual sales process, which would eliminate payroll, and involving some genuine physical interaction with the sale from that location, such as negotiating sales, accepting orders, approving credit, delivering goods to the customer, or billing, is what constitutes participation in sale. So do you, I'm trying to work with you here, but do you deny that the Ms. M submitted 30-day nominations?
No.
Okay. Then there was a 10-day period where those nominations or purchase orders were confirmed.
There was another estimate, a 10-day estimate, yep.
Right, okay, estimate or nominations, I think nominations is more the technical term. So the employee, you don't believe that the employee actually purchased the fuel?
No, we believe the employee was involved in making sure there was fuel on hand.
Okay.
Yep.
Okay, I'm through. Thank you.
So I do have a question. So was this Oakland office required to get a seller's permit?
Yes, Ms. Ma, we believe that they were required to obtain a seller's permit for that sales location.
And did they file taxes?
They did have a permit for that location.
And they filed their sales tax returns?
Correct.
Okay. Mr. Runner?
Yeah, just to, clearly what we're trying to find is we have a dispute in regards to this definition of participation and also to a degree in regards to trying to define what these nominations are and what the way how they actually acted. Let me hear again from the city of Oakland what it is that you believe took place with these nominations. Why were these nominations indeed participation?
I think it's important to make that evaluation in the context of the industry-specific process. This is how sales were consummated in the jet fuel industry. There were these increasingly more precise transactions starting with the master contract. Then the next level would be these location agreements. Then the next level would be these 30-day nominations, then the 10-day nominations, and then someone's actually putting the fuel into the plane. I'll concede Ms. M was not out there on the tarmac putting fuel into the plane, but for her involvement with this, that final act would not have taken place. So my understanding is how the process worked like this, that either the parent, or I must continue to emphasize, there was considerable third-party activity as well. We're not just talking about the parent-taxpayer interactions, but whoever was submitting the nominations would make these elaborate calculations in order to get as specific a volume of fuel as they could based on those various factors, the lift factors, the weather, the cancellations, any of these things, because in the industry, it was expensive for them to be carrying excess fuel on their planes. So as a matter of business practice, it was essential for them to have a specific an estimation, if we can use that word.
So the challenge is they didn't know the exact amount of the sale.
They could not know.
They could not know.
Yeah.
Let me go back to the department then. We would, at least what I'm hearing, is not knowing the exact amount of sale does not negate the fact that there was participation?
That's correct. That the participation could take place before, there's participation leading up to the time the sale takes place.
Okay. Let me go and ask a quick question to the taxpayer on the appeal side. You just went through and described the role of Ms. M, and it seemed to me one of the issues you said I thought I heard was overseeing purchases.
I believe I acknowledged to Ms. Harkey that she was involved in purchasing. Yep.
Okay.
Purchasing the fuel.
Okay. Let me just ask the other question. I'm just kind of, and it may or may not have much to do with it. I'm just interested in why it is that the legislature delayed the implementation of the bill. It seems to me that the legislature always does that for a purpose. And remind me again why you believe that they delayed the implementation of the bill.
Well, I guess maybe my first response is we don't know for sure because there's nothing specific in the legislative
But we know it's unusual not to.
We know. I mean, I think if you look at the history, there were some concrete reasons offered in some of the legislative history as to why there might be a delay or why it might make sense. I think at one point it was proposed that there be some sort of study done by the state controller to understand more about these types of arrangements and kind of what they involved and maybe some of the kind of the specific facts that I think would have been critical.
Right, but none of that happened. They just delayed the implementation.
They just delayed it, and so there's nothing in the history that indicates sort of specifically why they decided to delay it.
Member Runner, if I may.
I'm
sorry.
Okay. I'm compelled to feel like there was again, seems to me that if there was a concern in regards to the correction aspect or something that they believe was not done in a fashion that was, they're trying to undo or redo something, it seemed to me, I'm struggling with the fact that why it wouldn't be implemented immediately, or not immediately, but in the beginning of the year. So that's why I struggle with that. There seemed to be, and again, I guess we're all to a big degree guessing a bit. It seems to me that there was some acceptance to what the process was in order to create, in my opinion, some transition issues that would take place. Go ahead.
No, that's fine, Your Honor. I'll withdraw the comment.
So, I mean, I could offer a brief comment that I think Mr. Myers also had something he wanted to add. I mean, I think you're right in the sense that we don't know for sure. I think that's the concern, is that we don't want to be making a decision based on some assumption about why something happened. And I think that's compounded by the knowledge that we have today that there wasn't a full record for the legislature to really be deciding on a delay. Like, it'd be maybe a different situation if they had the record that's available today. They were able to look in detail at exactly what Ms. M is doing in Oakland and then decide, we're going to go ahead and say yes.
I'm not sure that was what they believed their job to be, but that's okay.
Well, but sorry, go ahead.
Oh, I think that's our point to some degree, Member Runner.
When was this bill done?
What's that?
2006.
2006
So a few of us were probably there at that time, huh?
Implemented in 2008.
There went implementation.
Yes.
Okay, go ahead.
No, I think that's precisely our point. To read the legislative history as saying that the legislature specifically found that this was participation, I think puts too much weight on the legislative history. It's not there.
Okay, thank you.
Ms. Ma?
Yeah, I mean, I would just like to add, sitting on rev and tax, we would usually extend the implementation because of planning purposes, whether cities and counties required more time to plan since, they already budget out at least 1 or 2 years, and therefore, implementing it too soon would actually...
Bad economic outcome.
Right, exactly. Ms. Stars.
Yes, to Oakland, I think you may have addressed it, but when you were speaking to Mr. Runner, but you said something earlier about how the industry operates.
Yes.
Can you, I'm sorry, but walk me through it again?
Yes, I think it's important to keep in mind that there is a sales process. There's a series of transactions at the end of which fuel actually goes into the wingtip. And those include these various stages, which are that are in the record. There's the master contract. There is what are referred to as the location agreements. Then there are these increasingly more precise nominations, the last of which is this 10-day nomination, which involves these very sophisticated methods of evaluating as exactly as they can what the customer's requirement is going to be at a specific airport. And it's important to keep in mind that the calculation is done by the customer, the specific customer at a specific airport. It's not as if they can go to the shelf and pull down X number of widgets that they have. This is a specific number that's generated by the customer saying, this is what we are going to need at this airport in this time period. So that's how the industry works.
And for our particular issue here, Ms. M interacted with the customer?
Yes. Yes, there could be no sale unless there was a purchase order, a signed purchase order received at the Oakland office. So there would be no fuel going into the wingtip, but for Ms. M processing the purchase order at the Oakland office.
Thank you.
Mr. Horton.
Thank you, Madam Chair. I just wanted to sort of weigh in on the legislation. The legislature generally is not a trier of fact, so I agree with Oakland that the legislation only comes into play prospectively. Even then, the facts are the determining factors as to whether or not there was participation. So the historical aspect of this is, I mean, I get the intent language and I get the implications, but I don't, that's not their position as a legislature. They don't determine the facts. So they would not have determined participation or the lack thereof in the legislative process. Surely discussions evidently took place, but that's I don't see the value of the legislation. But I do see the value of the various different activities taking place by Mrs. M, purchasing, participation, judgment, several judgment calls relative to the transaction and the contractual relationship of the parties.
Mr. Horton, Deputy City Attorney Paul Prather for San Diego. I just want to talk about this participation in the sale. There are certainly very important things that Mrs. M did to stock the warehouse. We have warehouses in San Diego. We have requirements contracts with other companies, and there are people there that make sure that that warehouse has plenty of product that can be ordered. So if participation in the sale is actually stocking the warehouse, then that may include a lot of things which hasn't been before this board. It's really an expansion of what has been done before, which is the actual, in our belief, the order which was actually made. There are no penalties if the plane doesn't pick up that fuel. There was no lawsuits from the taxpayer, no missed fees. I mean, it was purely an estimate was all that was done at that office. And until the plane actually pulled up, decided it was going to fly, that's when the order and the tax was assessed. So participation in the sale has never, that I've seen before, gone so far as to include stocking the warehouse, which if the warehouse doesn't have product, then indeed there can't be a sale.
Yeah. I mean, the inherent challenge with this entire transaction is, I think, was sort of codified by Thurgood Marshall as a Supreme Court justice when he basically said that there's nothing sinister about arranging one's finances in order to minimize your tax liability. And so it appears that the transaction was intentionally arranged in such a way that there was an element of participation from the initial issuance of the permit, wherein the permit would not have been issued unless there was some grounds of participation because the permit wouldn't have been necessary. So presumably back to the point in which the permit was initially issued, the activity, discussion, decision, the authority provided is informative and implies that the authority was there. And the evidence subsequent to the authority seemed to imply as well that some activity did take place. The measurement of that activity would cause this body to have to sort of micromanage and do the audit, which has been done by the department. The department has evaluated the evidence and measured it to determine if that was there. So, I mean, I do give credence to your argument relative to the stocking and the warehousing, but any element of participation and contractual relationship, authority, all those things kind of feeds into the participation. Now, whether or not in the legislature's wisdom, they said, well, we don't want this to occur anymore, you know. So that's their right to make a law, but unfortunately, from my perspective at least, we are the triers of facts, and we can only judge by the facts that they have presented to us today.
Okay, Mr. Myers.
And we're grateful that as triers of fact, you've taken your time to try to wade through this, and we appreciate that. It is a big record. A couple of items to note that I would urge the board's caution on. First, the fact that they were issued a seller's permit. The threshold for being issued a seller's permit is essentially that you apply for one. Secondly, the due diligence of the department. While there was in some investigation, most of the records have been produced by the taxpayer in the city of Oakland during the second appeals conference, not an audit. The initial investigation was they went to the office, showed up, saw that there was a computer there, and said, well, it looks to us like there's an office here. So I think we need to be careful of drawing conclusions from those two sources of authority. Obviously, if the board reaches a different conclusion than what we urge, we respect the board's judgment on that. The final point is simply this, and I think this is why this is a tricky case. There's no, at least on my part, I will not speak for Mr. Wong, but on our part, there's no disputing that Ms. M did important things for the business. Okay? But handling the purchasing side is not itself participation in the sale. That is a logistics matter. That doesn't mean it's unimportant. Doesn't mean she didn't have authority. Doesn't mean she didn't contract. And to the extent that Mr. Key wants to bring up, again, that there were significant profits on the other side, great. I haven't seen those in the record, but we are focused on the transactions between taxpayer and parent, and it has been conceded that she didn't negotiate those. She didn't have contractual authority there. She handled getting the inventory ready. Really important, not selling at retail. This is not a business license tax. It is a tax on the action of selling at retail. And to the extent that Mr. Creek correctly points out that it is a process, it is really a process in many, many business-to-business transactions now. We're not talking for the most part about people walking into an order and placing their order at the cashiers, at the cash register, and then walking out. We have a lot of instances where it's a process. That doesn't make them unique. And we would urge the board to hold the line and not allow inventory management to become participation. Thank you.
Madam Chair.
Mr. Horton.
Question of the department, and from your findings, the taxpayer has indicated that the only activity of consideration is the purchasing and warehousing. Did you find any activity other than that?
Well, we agree with the appeals decision that there was no negotiation. We agree with that. But we do see communication, emails between the purchaser, the parent in this case. So when we talk about, as we've discussed, when we talk about the purchasing of the inventory, it's in the context of their communication and their receiving these nominations from the purchaser.
The taxpayer has described your initial investigation as walking into the office, seeing a computer, and concluding that there was activity. My understanding is that initially you actually ruled against the City of Oakland. It was your initial finding, and then subsequent to that, the request of additional documentation, evidence came forth, and then you took the position. I don't want to describe what took place, but I do want to ask your investigation of the facts in this case. What did it entail?
Well, no, go ahead. I mean,
Nobody.
Bring out the gun.
Mr. Horton, yeah, it's a delicate subject to discuss, but this was typical of any of the local tax cases that we have where the department needs to obtain documentation to evidence that the sales took place in a given locale. Our initial attempts to obtain that information were unsuccessful, as I understand it. Some subpoenas were issued to various parties to obtain additional information supporting exactly what activities took place at that location. But it was with the issuance of that legal means that we were able to obtain a lot of documentation that documented the transactions that we're talking about today, sufficient for us to determine that order taking was taking place.
So it's your belief that your investigation was far more comprehensive than depicted by the taxpayer?
That's correct.
Mr. Myers, you have last.
I'm debating whether we should continue going down that road. I will simply say that this case was scheduled to come to hearing before these members, before the board, a couple of years ago. If I misstate, I'm sure Ms. Nino can correct me, but at that time, the decision and recommendation was that there was no participation, and that was after the department's investigation. So while I am loath to do so, I must give the credit where it belongs to the City of Oakland and Mr. Key, who in the supplemental decision and recommendation, in the second appeals conference, brought a lot of this documentation to bear. So I I only add that by way of saying, look, I'm not really here to disparage the department or anybody else, but I would say please be cautious in putting too much weight in the department's investigation. Oakland did bring forth a lot of this documentation, and we've argued from it. We'll see whether successfully or not, but thank you.
Madam Chair, I would like to go to appeals just to get their view of the evidence provided by all parties here and their conclusive analysis.
David Levine for appeals. Just for clarification, appeals has never regarded purchasing, regardless of how important it is, as an element in selling, and as far as I know, the board has not either. It is a process, but we focused on selling only. Here, if you, and Mr. Myers, we agree with a lot of what Mr. Myers has said, except a couple critical things. We reversed the department's finding in the DNR. The department found that there was participation at Oakland. We found there was not sufficient evidence. It was in the second appeals conference where Oakland came forward with the documentation that we've relied on now. And what we rely on is the nominations. If you agree with us that they equal purchase orders, then Regulation 1620, as Ms. Harkey pointed out, is explicit. Purchase orders are participation. We think that the nominations, even if they don't rise to the level of purchase orders, which we think they do, we still think that they are significant participation in the sales because they're a necessary function. That's how these things work. That's how they have to work in most cases. So granted, the nominations relate to having the inventory available, but it is part of the selling process between the buyer and the seller. So that's where we are at in this case.
Madam Chair, just a conclusive statement. When I was promoted to a tax counsel 4, this was one of my first audits of a local tax allocation dealing with fuel, and it was extremely complicated. I thought it was. And so there was tons and tons of evidence, purchase orders, fuel going in and out all over the nation and so forth and so on. And it was probably one of my first lessons also. The supervisor came in and said, Horton, what are you doing? And why are you spending all this time on this? Why don't you pull the master agreement and see if it's open-ended? I did. Master agreement was open-ended, which indicated that someone had to make a subsequent decision as to what actually was being transferred. Then he simply said, who made that decision and where was it made, And it's one of the unfortunate things that they can actually move an individual that's authorized to make that call into any particular city that they want to and allocate the local tax to that city. Unfortunate, and some might even say somewhat unfair, but it is the reality of the law at the time that we're called to make a decision. And I agree too, Mr. Myers, good arguments, good points, well done.
Thank you.
Having said that, do you want to make a motion?
No.
Anyone like to make a motion?
I would move the staff recommendation.
Second.
Okay. Okay, Mr. Renner moves the staff recommendation and to deny the petition. Mr. Horton seconds. Without objection, motion carries. Thank you, members. We are going to take a recess and reconvene at 1:30. Thank you all for coming.
Thank you very much.
Thank you.
Okay, welcome back to the meeting of the State Board of Equalization is hereby reconvened. Ms. Richmond, please introduce our next item.
Good afternoon, members. Our next item on today's agenda is item D, Special Taxes Appeals Hearings. Item D1, CK Specialty Insurance Associates, Inc. Please come forward.
Thank you. We note that this is a constitutional function and the Deputy Controller will not be participating in the vote, but will stay here. Mr. Anjija, please introduce the issues in this case.
Good afternoon, Chairwoman Ma and members. I'm Jeff Anjija on behalf of the Appeals Division. The appeal before you presents one unresolved issue, which is whether the inspection fees and policy fees were part of petitioner's taxable gross premiums.
Okay, thank you. Welcome to the Board of Equalization. Petitioner, you have 10 minutes to make your initial presentation, and you will have an additional 5 minutes on rebuttal. Please introduce yourselves for the record.
Bill Goswitz, representing CK Specialty.
John Sebastianelli, counsel for petitioner.
Justin Connors, taxpayer.
Okay. Thank you. Please proceed.
This is a matter under the California premium tax, but unlike most premium tax matters, this is not tax paid by an insurer or an insurance company. This is tax paid by a surplus line broker, because surplus line insurance is not, surplus line insurers are not permitted to transact insurance for themselves in California. They are required to have their insurance placed through a surplus line broker. So it's not, this is not an insurance company. The taxpayer is a Sacramento or a San Jose small business, 17 employees. The surplus lines insurers, taxation is taxed at the broker level rather than at the insurer level, because the insurers are not actually subject to California jurisdiction. So the payment that a surplus line broker receives for the insurance has to be categorized into, well, basically 3 buckets. That which is subject to premium tax. There's a payment will include a certain amount of pass-through income that is not taxable at all by the broker, and the remainder is taxed under the income tax. So the question here is whether the taxpayer correctly classified the income. Now, there are certain fees which, under the law, a broker is entitled to charge for his services. Unlike an insurance agent who actually represents an insurance company, a broker works for the insurance consumer, and thus the broker is allowed under the law to charge a fee to compensate for his services, which would be paid by the customer. In this case, the broker charged fees, which were variously called either inspection fees or policy fees. The names were given to describe the nature of the service that was being provided. The broker or the taxpayer, as I said, divided the tax up into the appropriate things, and had a question at one point about, do these fees go under the premium tax, in the premium tax bundle, or do they go in the ordinary income bundle? So he went to the Department of Insurance, and the Department of Insurance on issues like this operates under the law through an agent called the Surplus Line Association. But they are an agent in this function of the state of California. The Surplus Line Association gave the taxpayer a bulletin that they had published. The bulletin says that if the fee is required by the insurance company or the amount of the fee is remitted to the insurance company, then it is taxable under the premium tax. If it's a fee that the broker himself establishes and that the broker controls, then the broker can waive if he wants to, and the money is not in any way going to the insurance company, then it's ordinary income. Relying upon that relying upon that, the taxpayer paid taxes on these fees as ordinary income, since these were not fees that were established or required by the insurance company. The Department of Insurance later did an audit of the taxpayer, and they said, wait a minute, policy fees and inspection fees are taxable as premium. And the taxpayer said, well, wait a minute, no, the bulletin says if they're required or by the insurer, they are premium, and if they are not required by the insurer, they're not. So the point is the taxpayer went to the Department of Insurance, got the guidance, followed the guidance that was provided, and then in an audit afterwards, the department came up with what amounts to a different rule. It's important to remember that we're operating in the context of surplus lines, which is a unique circumstance. I'm not going to try and go through all of the details. I don't have the time. But the point is that this is a unique question of law. Now, the Department of Insurance and the board's proposed decision rely primarily on a couple of cases, Allstate versus Board of Equalization from 1959 and Groves versus City of Los Angeles from 1953. I want to point out that those cases are not on point. Both of those cases deal with taxes paid by by an insurance company, not by a surplus line broker under a completely different law, and both of those cases deal with taxes in the admitted market, not the non-admitted market. The rule that comes from those cases is stated in the Groves as premium. This is a quote. Premium in the law of insurance means the amount paid to the company for insurance, unquote, citing State Farm Mutual versus Carpenter. In this case, the fee income is not paid to the insurer. The fee income is paid to the the surplus line broker. The broker has the right to waive the fee, and in certain cases, the broker will waive the fee. The broker's not going to, if the customer objects to, I don't want to pay this policy fee, the broker's not going to let the deal fall apart because of that, and the broker has every right to, and often does, and often will, choose to waive a fee so that the transaction can go forward. So it's not money paid to the insurer as is referred to in those cases. By citing those cases, the department is attempting to expand the reach of those cases to places where they have never been. So in this case, in order to obey the law, the taxpayer went to the regulating agency and said, how do I figure this out? The regulating agency provided the taxpayer with guidance in the form of letters that had been issued by the Department of Insurance, one from 1994, the other from 1997. Told the taxpayer, follow these letters. The taxpayer followed those letters, and then in a subsequent audit, the department said, no, the real issue is, what are these called? Are they called, if they're called policy fee or inspection fee, they're premium. If they're called broker fee, they're not premium. We know that it's only the name that is determining the outcome, because in order to comply with the department's position, the taxpayer made changes in his procedures, and the only changes were he changed the names of the fees. And now the department's okay with it. So the taxpayer followed the department's guidance carefully. The fee income was properly taxed under the income tax. There is no issue here of tax avoidance. There's not even an issue of a taxpayer making a slick interpretation of the rules to to his benefit. What's happened here is that the department, after the fact, came in and said, no, the real rule is something other than what we told you about before. So the only thing that that pretends to be any kind of legal authority in the context of surplus line, tax paid on surplus lines by a surplus line broker is the guidance that was provided by the department in their 1994 and 1997 letters and subsequently distributed by the Surplus Line Association as a bulletin. Nothing else is explicitly a rule that a taxpayer could attempt to follow. So the taxpayer received the guidance, the taxpayer followed the guidance. The guidance is correct legally. The cases that the department has cited against us are not, the cases are not on point. And during the process of negotiating this, the board's specialist staff did a preliminary review and concluded that the taxpayer was correct. Now, while that opinion is not binding on the board, it's clearly evidence that the taxpayer dealt reasonably with the law and worked to obey the law. So we respectfully request that the board find for the taxpayer in this matter.
Thank you very much. Okay, let's go to the department. Please introduce yourself.
Good afternoon. My name is Laszlo Kamyati Jr. I'm an attorney with the California Department of Insurance, the entity that created the delinquent, created the assessment that was forwarded on to the State Board of Equalization, which then proceeded to send it out. Mr. Gossowitz claims that these are fees that should not be part of the premium taxed. And he says he recites relying on these letters as evidence that that was the position of the department. We respectfully disagree. We look at it and think he's looking at it quite narrowly and is not supported by the law whatsoever. First, when they say he didn't understand, his client didn't understand whether this was taxable or not, in my reply I did include as an exhibit to my brief instructions that were provided in 2007, 2008, 2009, 2000, for all the tax years, instructions on how to pay, what is premium and how to pay the premium tax. And when it goes to line 1, it states specifically how to pay the premium tax, and then it gives an example showing the policy premium along with policy fee and inspection fee are part of the total gross taxable premium. This is one thing that was every year shown to the petitioner who filed his tax returns, that yes, these policy fees and inspection fees are normally considered taxable. Next, there is the Bulletin 80-6 was issued by the by the department in 1980, explaining various fees and things in there. And in there, they said that as a general proposition, citing Grove versus the City of LA, which is a Supreme Court decision, as long as Allstate, that as a general proposition, all sums paid to the insurance agent is deemed premium for purpose, is deemed premium. Then it goes on to talk about what a broker's fees must be agreed in advance, and also talks about it's objectionable to disguise a broker fee as to a client to be categorized as an inspection fee when no inspection is required, or a policy fee when no policy fee is required or authorized by the insurer. Petitioner acknowledges that these fees in question were never required by the insurer or authorized by the insurer. He was allowed to charge it. He claims it is essentially a broker's fee, even though it's categorized otherwise. However, when in doing it, he created invoices that listed these separately, and he also required the surplus line broker is required to, when issuing a policy such as this, in the certificate or the declarations page, to state what the premium is. This is the notice that's required to be given to the policyholder. They go through it, they can tell, and it's identified in those documents as premium. Having identified it as premium in the first instance, and then, like I said, the 80-6 talks about these are all part of what is deemed premium. Now, counsel, in discussing it, is relying on one of these letters, and he's separating. There's a letter of August 8th, 1997, identified in the surplus line as Bulletin 806. In there, in the third paragraph, in response directed to Deanne Zanoni, Director of the Surplus Line Association, it goes on to state, if the insurer requires or imposes a fee to be charged as part of the cost of obtaining the insurance protection, then the fee is to be treated as part of the taxable premium regardless of who retains the fee. Policy fees and inspections fees are common examples of fees that are generally taxable. The next paragraph goes then to talk about negotiation and where, if there's a negotiated fee, et cetera, it must be levied solely for the benefit of the surplus line broker and not remitted to the non-admitted insurer. This is the sentence that counsel is relying on to argue that, well, even though we call it a part of premium, even though it's listed as premium, even though the instructions for filing tax returns clearly identifies these as all premium, because we charged it, we didn't disclose it, that it's not part of the premium. We disclose it as part of the premium, but it really isn't premium, therefore it's not taxable as part of the basis as a gross premium tax. Well, that is clearly erroneous when they are issuing the policies on behalf of these non-admitted carriers, and they are inserting in there that this is part and parcel of the premium that is being charged to the client. Now, the broker's fee is interesting. On the invoices that they issue to these retail brokers, they list all these different fees. They also list the broker fee that they're charging. However, they don't list the broker fee in the declaration page or in the certificate. They only list those fees that are normally considered to be premium-related fees, the policy fees and inspection fees. Here, to me, it looks like they looked at this and said, oh, well, if we throw it in as an inspection or a policy fee, the purchaser of the policy, the customer, will believe that these are part of the premium and is required to pay it. In fact, on the declaration pages, as references, a failure to pay these amounts will result in not having a policy in force. For these reasons, it's clear to me that under the California law, the statutes, and that these are clearly part and parcel of the basis that is included in the premiums for purpose of paying a premium tax that the surplus line broker has to pay. The fact that if a surplus line broker retains those same items where an insurer has in fact said, go ahead and charge the inspection fee, and you can keep the inspection fee, the tax is imposed on the insurer. The broker keeps the money. The broker also has to pay a personal income tax on that same fee. There's no double taxation. One is, what is the basis for taxing an insurance company or a non-admitted insurer? Because these are policies that are not available in California, and a customer, in order to get that type of policy, has to look outside of the state to a non-admitted insurer. They cannot be licensed in here, but they have to go through a surplus line broker unless the customer goes directly to the company, that non-admitted carrier. So they go through this process. This 3% fee is charged, and the surplus line broker is required to pay that amount on the total gross premium. And those two items are, in fact, part of the premium, the inspection fee and policy fee. And the determination should be upheld that this amount is due.
Okay, thank you to the petitioner. You have 5 minutes on rebuttal.
Again, the issue, and you saw it in the department's presentation, they said that these fees are taxable because they're named inspection fee or policy fee. But the legal test that is in there is whether the fees are required by the insurer. And it says, whatever they're, frequently, the various guidance says, whatever the name is given, that the test is are these fees required by the insurer? And the fact is that these fees were not required by the insurer. The funds were not remitted to the insurer. And this remains the only legal rule that clearly applies in the context of tax paid, premium tax paid by a surplus line broker. The department has not come up with any other rule that says, oh, if in a surplus line context, this is how you figure it out. It's only this letter. The department cited Bulletin 80-6, but Bulletin 80-6 applies to admitted insurance and non-admitted insurance and all kinds of, it applies across the board for all insurance. It is not a rule specific to surplus line or premium tax paid by a surplus line broker. The department just quoted the Groves decision, and he said that it talks about money paid to the agency. The fact is, this isn't an agency, it's a brokerage. The Groves decision and the related Allstate decision deal only with premium tax paid by insurance companies in the admitted market. They don't deal with premium tax paid by a surplus line broker. In this case, what the taxpayer did is asked the department for the rule for figuring out what these, how to properly categorize these fees. The department provided that rule through the Surplus Line Association broker. The taxpayer followed the rule, and after the fact, as a result of an audit, the department came in and said, no, the real rule is that it's the name of the fee. If it's called an inspection fee, it's taxable. If it's called a policy fee, it's taxable. And we believe that that is not the correct rule. We believe that the correct rule is the one that the taxpayer followed. And on that basis, we ask the board to fine for the taxpayer.
Okay, thank you. Members? Mr. Renner.
Sure. Yeah, let me, let's go to that point in regards to the issue, in regards to what's the controlling issue. Is it the labeling of the fee, or is it the issue of being required by the insurer? Let me go to the insurance.
Okay. It is, the thing is we're looking at what has been given to the policyholder. The declarations page, going to the insurance code 381, it says certain things have to be stated in the policy, and this is to protect the consumer. And in that policy, you're supposed to state what the premium is. So here, the petitioner, in preparing the policy, is issued by the petitioner on behalf of this. He's acting as an agent for these non-admitted carriers. When he's issuing these policies, he could have easily not inserted the policy fee or the inspection fee in the declaration of what is the premium. Instead, he inserted that in there. That is being disclosed under the California law saying what is the premium. You're supposed to state the premium under 381 as to be what it is that is being charged to the customer. Those items on each of the policies are included as part of the basis for the premium.
So you don't think it's as simple as if it doesn't, isn't it required by the insurer, then it's not?
No, it's not that simple. Those, if you read through those letters, because the premise starts with 80-6. That's the bulletin that was issued by the Department of Insurance. These other bulletins that were issued by the Surplus Line Association. That has been tasked with trying to assist.
What is the relationship to that organization to the Department of Insurance?
It is a separate entity that is allowed to charge, if they even charge a stamp tax for doing this service. They act as a service to provide the surplus line interested, who are authorized, who are these various insurance companies that have been accepted. They're called like the Leslie list, who are authorized to do. These are all various things to help facilitate the issuance of non-admitted insurance company policy.
They work as an agent to the Department of Insurance?
They don't work as an agent. They're a separate entity tasked to provide this information.
Who are they responsible to? Who oversees their work?
I don't think there's anybody per se that they oversee it, but the department has purview over them. There's no question the department tasked them with this ability to provide.
The department gave them this responsibility?
Yes.
The department oversees that they fulfill this responsibility correctly?
They're supposed to, yes, correct.
They do, or they're supposed to?
Well, in general, I presume they do. I don't know of any time they don't.
Okay. So why wouldn't I understand that they're like an arm of the Department of Insurance?
Well, an arm of insurance would be actually part of the agency, and they're not.
Why wouldn't I see them as an agent of the department then?
Because they're listed as surplus line agency. They're not listed Department of Insurance on the heading. They're not.
So it's just a semantic
No,
thing?
I mean,
Just
they are not.
what they're described as, not what their job is?
Well, you may be tasked, for example, I may task you as an agent, but you're not going to say, well, I may, that's a bad example. Anyway, they are tasked with, they were given the
Who
authority.
tasked them?
The department.
Okay.
The commissioner
Thank you.
did, I should
think
say.
I
The
get it.
commissioner did.
I think I got it. Let me ask this. If indeed, and I guess this is, I'll start with the taxpayer. If indeed this was looked at as you dealt with this as ordinary income, I assume then there was a income tax paid on that.
Yes, there was.
Okay. Let me ask, if we go ahead and fine then for the department, aren't we double taxing them?
No, because you're taxing on the gross premium that's being charged. Here in a regular estate, same situation, if he was an admitted carrier, these fees that they retained, it would be subject to gross premium tax. And because he retained, the agent or the broker retained those fees, they would pay taxes on that personally. So it's not being double taxed. It's two separate taxes. The first tax is related for, like, example, in California, the insurance.
Don't you pay one or the other?
No. The surplus line broker is obligated to pay a tax on the premium that is generated in the business. An insurance company admitted in California also pays a tax on the gross premium generated for the business. The fact that from those premiums, money is retained by the broker or the agent does not reduce the tax owed by the insurer or the surplus line broker. The agent gets that money, has to also declare it, and has to declare that as part of his income generated from his business.
Okay, let me ask if that's the way that the taxpayer sees that discussion.
Yeah,
ahead,
exactly. If we are forced to pay, I think, this unjust tax, we're going to be asking for a tax refund from the state because our profitability is going to be much, actually negative for these years.
So you would believe that if indeed we found in the department's favor that it would affect your state income tax status or your filing at that point?
It would.
And you would then have to refile?
Yes.
Is there where are we at with statute of limitations on this, on a refund?
We're probably past it.
Okay, so you wouldn't have the ability to do that?
So, yeah.
In effect, it would be double taxation.
So you don't have the ability to go and get the correction then with that?
Correct.
That's correct.
Okay, thank you.
Mr. Renner, the authority of the Surplus Line Association is created by statute under Insurance Code Section 1780.56. It specifically says that the department may employ the Surplus Line Association as functionally, it is an agency of the state government in that capacity under agency law, but it is by statute.
Okay, thank you.
I just have a couple questions about these invoices that were in our packet. There's usually 5 lines. It says premium, policy fee, inspection fee, state tax, stamp fee. Those are the ones with the most.
Right.
So can you explain to me what each one or how each one is charged?
One of the things that has made this a difficult case is that you have the same word, which is used in different terms. Premium, as the department was just talking about it, is essentially the check that the policyholder writes, as opposed to, in this case, on this invoice, premium is the amount that is charged by that is going back to the insurance company to compensate the insurance company for writing that policy. Policy fee and inspection fee are fees that are imposed by the surplus line broker, which are not required by or remitted to the insurance company at all. Those two fees, it's entirely within the discretion of the broker, whether they appear on the bill or at all, but those are the fees whereby the broker is compensated. Stamping fee is essentially an administrative fee that is paid to the Surplus Line Association for the various work that it does on behalf of the Department of Insurance under Insurance Code 1780.56. And then the
State tax.
the final one, state tax, that is money that is paid, it's essentially a pass-through. That's because the surplus line broker is going to have to pay taxes on premium taxes. They will collect that money from the insurance company. If you look at it, that premium, that amount that says for state tax should be exactly 3% of the amount that is listed as premium. Is that correct? Because that's how it's calculated.
Okay, so I'm looking at the few invoices that you submitted or your client submitted. The state tax and the stamp fee and the premium all appear on each one, yet the policy fee and the inspection fee, sometimes they appear on some one or the other. How do you decide which one you're going to charge?
It's a business decision, essentially.
Yeah, it's completely negotiable. The people who are purchasing these policies are business owners, typically small to medium businesses. They have to go through, they have to sign disclosures stating that they understand that this insurance is non-admitted in California. In other words, these are not licensed insurers. They're not regulated by the Department of Insurance. The Department of Insurance doesn't make rates for these insurers. So these retail insurance brokers who represent the insured, and at that point, when I am trying to obtain the best coverage for the client of the retail broker, it's completely negotiable. There's instances where they say that they're really struggling. Can you waive all your fees? And we do that to retain business.
And so the only two fees that you would add on are these policy fees or an inspection fee?
Yeah, well, currently we call them broker fees to appease the department. Yes.
But that was the practice back then?
Yes.
Which, again, is evidence of our argument that what the department's is doing now is they're saying it's the name of the fee that determines whether or not the fee is taxable. And our position is that's just not the proper legal rule. The legal rule is it required by the insurance company or is it paid to the insurance company? And we know that the department's position is that it's the name of the fee because the taxpayer was able to satisfy the department on the issue simply by changing the name of the fee.
Okay. Ms. Harkey.
For the department, the appellant claims that just by changing the name of the fee, it's all good. So have they been through an audit or anything since?
Since then, I'm not aware of it. However, if they did change the fee to broker's fee, I suspect that it's no longer appearing on the declaration pages or on the certificate that is being issued to the policyholder as part of the premium, because their practice in the past has always been broker's fees are not listed in that I saw. They're not listed in the declaration page or on the certificate. Rather, it's strictly on the invoice, which clearly tells the purchaser that this is not part of the premium. In these matters, the ones that are at issue here, they always inserted these inspection fees and policies fees on those declaration state required by statute and listed as part of the premium. Now, one of the things he mentioned that, well, if his client, if the insurance companies would have said, CK Specialty, you can charge an inspection fee and you can charge a policy fee of the amount they charge and you get to keep it, then they would not argue that, well, then it's because it was required by the insurance company. It would be unquestionably gross premium because they charged it, even though he got to keep it. So they'd be charged, they'd be paying the gross premium on the total amount, including those fees, and then the CK would have kept those fees and would have to pay income tax on those fees that were generated. The only difference here is they elected on their own to insert these as additional fees and disclose them as part of the premium instead of being strictly a broker's fee. If they would have been all along from the beginning said, we're not charging $500 in broker's fees, we're charging $800, then there's no question because it's not part of the listed premium that is required to be put on those policy, on the declaration page.
Okay, for the appellant,
Well-
just let me ask some questions. I'm trying to get this straight. How do you assess your broker's fees? A certain percentage of the policy?
Typically, what we do for policies that have premiums below $20,000, the broker fee, the fee that we charge for our own benefit is between $150 and $250.
Okay, so it's a flat fee.
But it's based on the negotiation with the retail broker for
Right.
each and every policy that's
What I'm
placed.
trying to get at is, did you charge a percentage of your total invoice? And apparently not.
No.
You just go, okay. So the next thing, did the retail broker always pass inspection fees and policy fees on to the insured?
Yes, not only did the retail broker pass the fees that we charged, the retail broker also includes their own broker fees, which can be quite large. In my experience, I've had policies where we've written it for a $3,000 premium, charged $200 broker fee or policy fee or whatever you would like to call it, and the retail broker comes back to us and says, I'm sorry, we can't sell that. I need you to reduce your fee. We do so. They order the insurance from us. We receive a notice of finance premium, and on there you can actually see what the retail broker charged. They charge the exact same amount as the premium. So yes, there are lots of fees that are passed down to the end consumer.
So what you're saying is the retail broker could just absorb the fees or
That's true.
pay you, but not charge the insured?
That's correct, yes.
Could the broker challenge the fees and get them reduced? You just said they could, correct?
That's correct.
Okay, even though they're listed on the certificate, they could still do that?
Yes, that's correct.
Would you then go back and adjust your certificate, or?
Yes, we would do that via an endorsement. The insurers, these are national, often multinational insurance companies. They design the certificate of insurance. They tell us to put our fees on the certificate. The department is suggesting that we could somehow remove these fees if we wanted to, and they said, since we're now calling them broker fees, they suspect that these broker fees are not listed on the certificate, that it's incorrect. These broker fees are listed on the certificate, and it's done so because these large insurance companies require us to do so.
Okay, for the department, if these fees were not actually charged to the insured retail broker, or if the broker had discretion whether to negate them or challenge the fees, would your position change?
Well, as they indicated that if they did do that and did not charge the fee and decided not to do it, that they would issue an endorsement
And so-
reflecting the reduced premium.
Right, so what you're saying is that what you have is just the standard sheet with endorsements. You considered all endorsements and
Correct.
netted those out.
That would be, because the endorsement says, oh, these fees were not charged to as part of the premium, therefore the total premium is reduced. Now, the one thing he says the broker's fees are included. All the exhibits I've seen in the past that were part of this whole proceeding, I never saw a broker fee listed under the certificates. I always saw inspection policy fees. The broker's fees were always just in the invoice. So maybe they do and put them in there now, I don't know, but these clearly, the policy fees, I should say the certificates and the They all have only listed the policy and inspection fees. The broker's fees were only included in the invoices.
Ms. Harkey, we're talking about two
Yes.
different, I apologize
I'm
for
sorry.
jumping in, but we are talking about two different things here. The taxpayer was talking about the procedures that he follows after he changed the names of the fees from policy fee and inspection fee to broker fee. So the examples that the department is referring to are all examples from the period before that change was made.
Right, and before that change was made, I guess, did you issue endorsements when you changed things? Did you have a policy? Did you adjust the policy?
Yeah, so if, it would be a very, let's say, extremely rare situation where after the insurance was purchased, that they would come back and ask us to waive the fee. We would do that via endorsement because we're required to file every single endorsement that every single endorsement to the policy needs to be filed with the surplus lines department, whether or not there's an additional premium, whether there's a return premium, whether there's a zero premium. And we would consider these endorsements removing policy fees or inspection fees or broker fees. Some of my competitors call them service fees, processing fees. They call them, there's many names for these surplus lines broker fees, as we call them now. We would consider that a non-premium endorsement, but we're required to do the endorsement to give it to the surplus lines administration so they can file it along with all the other documents that we're required to file when a business owner procures this non-traditional insurance.
Can I just ask you, in your mind, what is the difference between an inspection fee and a policy fee? Like, why wouldn't you have just charged one broker's fee, and why did you have to split it up into two?
We didn't, and that's what we do currently. We just call it a broker fee currently.
Right, but before, you split it up into an inspection fee and a policy fee. Like, what's the difference between the two fees?
Well, the difference is that generally when it's listed at an inspection fee, that means that we're using that money to order an inspection from an inspection company.
So if you didn't have to order an inspection, you would not have charged the inspection fee?
Correct.
So the policy fee is really similar to your broker's fee today?
Correct.
Okay. Any questions? Mr. Horton.
Thank you, Madam Chair. I just want to follow up on your line of questioning. The inspection fee I want to make sure I heard your testimony correctly, is to inspect what?
The inspection fee is to inspect the, usually the property of the insured.
For what purpose?
So as a surplus lines broker dealing with non-admitted insurance, we have what's called a dual agency capacity. And at the very beginning of the process, when the insured or the applicant is seeking insurance, our actions, canvassing the marketplace, obtaining the often difficult policy language amendments that are required by these business owners, coverages that are not obtainable in the admitted marketplace. We are acting on behalf of the applicant via the retail broker. Once the insurance is purchased, then we become an agency of the insurer, whoever they chose to purchase the insurance, whatever company they purchased the insurance from. So we're considered an agent of the insurer, but not an agent in terms of how the Department of Insurance would define agent.
No, I understand the relationship.
Yes, exactly. So, yeah, so this inspection fee we use to determine whether or not the risk is acceptable to the insurance company. Oftentimes it is acceptable to the insurance company, but it's not acceptable to us because we want to run a profitable book of business.
So you inspect the property,
Yes,
you examine the property
yes,
to ensure that the risk you're taking is measured relative to the potential outcome some point down the future?
exactly. It's to keep everybody honest. So there are instances where retail brokers will purposely misclassify a risk.
And what is the policy fee? What services are provided?
The policy fee, when we were calling them policy fees, that fee was for the benefit of our company. It was the cost of us going to multiple insurance carriers, obtaining different quotes from different carriers. Obviously, at that point, we're not an agent in an agency relationship with a particular insurer. We're shopping for the best coverage and price for ultimately the insurance purchaser. So that was the fee that we charged for our services to ultimately the insurance purchaser.
Question of the department, why do you deem these fees to be non-broker's fees?
Well, for a couple of reasons. One is, again, a policy fee is usually, and if you're dealing with admitted carriers, policy fees are charged by the insurer for issuing the policy. Here, again, when you do that, you are required under the law, under the 381 of the Insurance Code, you have to list that as part of the premium that's being charged. They said there's a policy fee as well. They're going out there canvassing. It's not really a policy fee then, because a policy fee is for issuance of a particular policy. At least that's my understanding of a policy fee, is when a company's issuing me a policy and they charge me a fee, that's for issuing that particular policy, not for going out and canvassing. To me, that sounds like I'm doing what a broker does, is going out there trying to facilitate. And instead of charging it as a broker fee, I'm calling it an inspection fee. To me, that I think is the purpose is more, from my perspective, if I'm a consumer, I look at that as you're trying to tell me that this is a fee charged for issuance of that particular policy. Your broker's fee is for going out and canvassing. An inspection fee, if they're going out to charge for it, they're doing that, that's a service. They're doing it, as you said, on behalf of the insurance company to ensure that that policy that's being placed is in fact being placed for that particular risk, and it's not for another piece of property or an unidentified piece of property because they didn't do the inspection. If the insurer would have said, okay, go ahead and charge that policy fee because I want you to make sure that it's a good risk, and you can keep the policy fee, again, it would be taxable as premium because it's required by the insurance company. Here they're doing it for the benefit of the insurance company, and they're listing it as premium, but they're saying, well, it's not really premium because we charged it, we collected it, but not the insurance company, even though we're doing it for the benefit of the insurance company.
And did the customer, is the customer aware of these fees?
I assume so. In the summary.
This is, excuse me, remember, this is, he's a wholesaler, so he deals with the retailer. The retailer was certainly aware of the fees.
Retailer's aware.
The retailer's aware of the fees. Whether the retailer passed the fees on to the customer is beyond the scope of what he knows.
I don't, his customer, the retailer.
His customer, the retailer, the ultimate consumer has the relationship with the retailer. The retailer goes to the wholesaler and says, can you find me the product? So the wholesale, the
much
fees.
appreciated. I understand the relationship. The question of the department, I want to kind of get away from semantics, and I'm presuming, if not, let me ask, did the department do some sort of analysis to determine what these fees were for and whether or not, in this case, the retailer presumed what the documents conveyed to the retailer that they were part of the premium or part of a service not in connection with the premium? And I guess the third question deals with the conditions subsequent to these transactions. I try to stay away from those hypothetical questions, but subsequently, they now claim that they treat these as broker fees. Do they have that option to shift the fees or to reclassify the fees?
Well, if you're listing it as a broker fee, all I can do is look at what was submitted by them, what the department would be looking at. They'd be seeing invoices, they'd be seeing certificates, declaration pages. Now, on all these declaration and certificates...
No, my apologies again. Don't mean to interrupt you, but at some point, I believe the taxpayer has made this argument to you before. It's not the first time this argument's come up. And when the argument came up, that you asked for some supporting documents or something that would negate the form over substance, how they recorded it, how they reported it.
Well, first, I would disagree that this is form over substance.
I'm not saying that.
Okay.
But that's the argument.
Right.
The argument is that it is form over substance.
Well, again, when when a policy is issued under California law, they're required to state the premium. That's under Insurance Code 381. And that has to be stated in the certificate or in the initial pages. And they did that. They inserted that as part of the premium, and the policyholder, when they get the policy, they will get that certificate. They will get those statements, and in there, it'll say that this is part of the premium. So as a policyholder, I would assume that this is part of the premium that's paid. Now, I get an invoice on top of that, and the invoice says, in addition to these fees, there's additional fees that are separate, that are listed as broker's fees. That's not in the, it's not in the certificate.
Okay.
So it's a complete, if it's in the certificate, you're stating to the world that this is part of the premium that's being charged.
What are the departments of insurance, you guys sent an advisory letter, I believe? 1997, somewhere around
Well, what happened is...
What did that say?
The letters, what happened is that there is some, as he had said, there was some questions as to the brokers were not paying premium tax on these fees because they were keeping it and not forwarding it on to the insurance carrier. So these additional letters that are issued by that were sent to the Surplus Line Association, who then turned around and created this as additional statements. And in there, they tried to explain what was going on, and each time it said normally these are considered as as part of the premium. And in the last one, they explained in that one paragraph, as I stated, that this is normally considered part of premium. The next paragraph says if you're negotiating, et cetera, those broker's fees, if it's broker's fees, it's not part of the premium.
Question of the taxpayer. You continue to document these fees the exact same way. You didn't change the way you documented the fees, the way you communicated the cost to your retailers or anything. Still same form, same?
Yes.
Different name.
Different name, although some of the insurance carriers that we deal with now list total premium, and they list the premium that we pay taxes on, and underneath that, there'll be the fees. So it's very clear that these are not, that these fees, including the tax and stamp fee, are not premium. But yes, so everything that we have control over, we do it exactly the exact same way that we've always done it.
Do you use this income stream now to perform the same services?
Yes.
And the department hasn't looked at that yet?
No, they haven't.
So the department hasn't made a call based on the actual services provided and whether or not it's premium or not?
Yeah, we're, as was mentioned, we're a small 17-employee business. All of our competitors are usually have hundreds to thousands of employees, and they do the exact same thing that we do.
Well, I'm not going to ask the department because I don't want to give them an invitation. So I'm going to leave it alone at this point.
Okay, members, or a motion?
I have,
Oh, Ms. Harkey.
I have just another question. Thank you. Okay, the Surplus Line Association came out with a letter clarifying that inspection and policy fees are examples of fees that may be part of a taxable premium. But whether or not they are required to be paid, and since the fees were not charged or required by the insurers, that was another letter that the fees had to be required. If they weren't required or paid to, that they weren't. So I think this is a very much a confusing point. And they listed their broker's fees, I believe, on their statements as premiums, but you agree that those are not part of the premiums.
Yeah, because they were not listed in the declaration page or on the certificates that are issued as part of the policy.
Okay, so what I'm trying to figure out, that they got letters from the Surplus Line Association saying that they had to be required or paid in order to be part of the premium, but if they weren't required or paid, and they weren't required or paid is what I'm hearing, they were sometimes paid and they sometimes weren't, but they weren't necessarily required by the SLA. So I think that's where the rub is like, now that he's changing them to be in a different part of the page, if you have them above the line, you have to pay the tax on. If you have them below the line, you don't have to pay the tax on, but they're still the same thing. Are they not?
Well, if you are representing that they are part of the premium.
Okay, so it's a disclosure issue for you?
That's part, yeah, because on 381, it says when you issue a policy, you have to disclose the premium, and you have to put it on the declaration page. The broker's fees don't appear on the declaration page, but the inspection fee, which they say is essentially the same thing as a broker's fee, they put it on the declaration page. Would have been, I think the issue would have never arose if they would have always said, these are all broker's fees. We're going to charge broker's fees.
And that's what they're doing now?
That's what they're doing now. Back then, they were putting it on the inspection.
Okay,
Yep.
thank you. I think, just in passing, I really think Department of Insurance needs to write some guidance and clarify, rather than leaving it up to the Surplus Line Association. If you're going to be doing the auditing and whatnot, you really need to clarify the reg.
I'll make them.
Well, the thing is these are not regulations, this particular part or not.
Well, what is it then?
These are guidance, because regulations, you have to go through a whole process.
Okay, so these are guidance. So the
Correct.
SLA issues guidance letters or memos or clarification letters. You issue
Yeah.
guidance.
But I'd also just...
I'm trying to figure out which trumps what, okay?
Well, I'd like to point out to the panel again that back in 2008, when they filed these tax returns, that subject, it says right there on the instructions that these premium, as part of your premium, is examples, the inspection fee and the policy fees are included as part of the basis. So as a taxpayer, I know when I get something and I'm doing my taxes and the government tells me that these are part of what I'm supposed to clear as income, that's what I would look at first, rather than going, okay, I got this one, let's see, how can I avoid not being taxed as premium?
Well, it sounds like this is just almost like an accounting error to me. I'm just confused.
Or a nomenclature.
Sorry.
Yeah, I'll make a motion for
Just one last
discussion.
question,
go ahead.
Madam Chair. A question of the department. How would you distinguish this, or would you, from the Grove case?
The only...
Anybody?
I don't think we would distinguish it from the Grove case. In both of them, the insured was not permitted by law to transact directly with the insurer. And that's why we were looking at Grove, because the question here is whether the gross premiums are the amount received by the insurer, or the gross premiums are the amount the insured thinks that they have to pay in order to obtain the insurance.
Right.
And Grove is a case where the insured and the insurer had to deal with the third party in order to get the insurance. So that's why staff has been looking at Grove for guidance, and there the court said that in these situations the test is how much did the insured have to pay in order to obtain the insurance.
Right.
So that's why we've been looking at that instead of how much did the insurer obtain.
Yeah, therein is my issue with the, or reservations, as if you will, with the argument of the taxpayer. Similar to contract law, or which basically, what's the understanding of the parties? You have a communication that's been communicated to folks. When you communicate it as part of the premium, then it is. Subsequently, you have the options of saying, I'm not going to charge those fees anymore, and I'm going to charge something different. But even in that environment, if you charge something different, call it something different, but it still quacks like a duck and is presumed to be the same, you run a risk of it being treated as premium regardless of what it's called, if all the parties involved have the understanding that that's the case. So, anyway, thank you.
Okay, Mr. Renner.
I make a motion to to grant petition for the taxpayer.
Objection.
Need a second first.
Is there a second?
Let's see if we get a second first.
I thought it was automatic.
Okay, for the discussion on the motion then.
Okay, discussion on the motion.
It's a couple of things that are compelling to me. One is, it seems to me that we have is trying to is a difference in terms of the definition of some of the terms, and I think part of my concern is that the department may be trying to apply the terms as if they were a California admitted company, and therefore these terms are understood, when in fact they're not, and they're using these terms in a different application. Now, what they've learned is to use them more consistently now in order to avoid this problem. But it seems to me that's part of the issue. So whenever you go back to the instructions that says these are part of the premium, the problem is that those are instructions, I think, that would be understood by a California admitted insurer, but not necessarily then understood that's the application to a non-admitted insurer. The other thing that does bother me a bit, and that is there was a tax paid on this. There was tax paid on this. And so I'm troubled with the idea that somebody may, if we find for the department that there is the potential that indeed we are taxing them once again, and they do not have the ability then to go back and address then their income tax filing because of the time that has passed. I don't know what it would mean to their income tax. I don't have any idea. But I think just the fact that they can't do that is a concern for me for the potential of a double taxation. So that's why I would fine for the taxpayer.
I appreciate that. I mean, I appreciate the sentiments relative to the statute of limitations. Unfortunately, the law does not provide when the statute of limitations has run and you no longer have that option that this body shall adjust for that. And it also doesn't provide that that's double taxation as a result of the running of the statute. The law is clear that it's not double taxation. The definition, I think that's the challenge that we face, is that we've been dealing with definition as opposed to how it's actually treated, and how the understanding of all the parties, what the understanding of the parties is. If it's treated, if you place it in a column as part of the premiums, treated as part of the premiums, understood by the customer as part of the premiums, at that point it becomes part of the premiums. If the decision is to treat it differently, no matter how you define it. You could have called it something other, but it's how it's treated, it's how it's classified, it's how it's at least pursuant to the law. And so the definition is not the governing fact in the decision, it's how it's treated and how it's understood by the parties, consistent with any contractual relationship that anyone has. There's nothing new about this or confusing from my perspective.
So I also see this as a nomenclature issue. I think the policy fee is a service fee, is a broker's fee. It wasn't required by the insurance company. It was not part of the premium. It was basically an additional fee for service charged by the broker in the situation to match up the insurance company to the retailer. So I see this as, policy fee, broker's fee, service fee. It's kind of the same fee that was negotiable. It wasn't mandatory. A client could decide whether they wanted to take the policy if the fees were too high or not. So that's where I'm at. Oh, you're not voting. Oh, that's right. Sorry. I was like, you're so quiet today. Okay. So, Ms. Richmond, please call the roll.
Ms. Ma?
Aye.
Ms. Harkey?
Aye.
Mr. Horton?
No.
Mr. Runner?
Aye.
Motion carries.
Okay,
Thank you very much.
Thank you. Thank you, members. And I think we have one more item today on the agenda. Ms. Richmond?
Our last item is item F, public hearing, item F1, proposed amendments to sales and use tax regulation 1698 records and special taxes regulation 4901 records.
Okay, to the department, please introduce yourself and also commence your presentation.
Thank you, Chairwoman Ma, members of the board. I'm Pamela Mash from the board's legal department, along with Bradley Hiller, also from the legal department. I'm here to request that the board vote to adopt the proposed amendments to sales and use tax regulation 1698 records and special taxes regulation 4901 records. The proposed amendments define the term electronic cash register, update the terminology to used to refer to electronic records, and clarify taxpayers' record retention requirements. Thank you.
Okay, seeing no public speakers?
Move to approve.
No.
Okay. Motion to approve, seconded by Ms. Harkey. Without objection, motion carries.
Thank you.
Are there any other items, Ms. Richmond?
That concludes our business for today.
Okay, so thank you all for attending today. This concludes the first day of the meeting of the State Board of Equalization. We will take a recess and we'll reconvene tomorrow morning at 9 a.m. Thank you all and have a nice evening.